Leave, my lord, to move an unlisted motions, my lords, at 2 p.m., my lord. What happened, my lords, my lord, the order of demolitions has been passed, my lord, yesterday, my lord. And when the order was, my lord, obtained at the 4:30, my lord, then the petition was drafted, my lord, copy for your lordship. 24th, my lord, 22nd, my lord, on Sunday, my lord, the boundary will be demolished, my lord, by the subdivisional officer, my lord. So on the ground, my lord, it is a long-term settlement, my lords. Since 2004, my lord, this was going on, my lords. All, my lord, paraphernalias has been completed. Government has agreed to grant land, my lord, without appreciating all these facts, my lord, passed an order directing to demolish the boundary wall. This is the steel industry, my lord. It's adjacent land, my lords. Long-term settlement has been agreed, my lord. All paraphernalias has been complied with, my lord, that no objection certificate from commercial department, from land revenue department, from all others department, municipality, panchayat, everything.
Put the other side on notice.
So, my lord, just, my lord,
Please put the other side, and I will not hear in absence of the other side.
no, I'm giving notice, my lord, to the landed government pleader, my lord, and I'm coming, my lord, at 2 p.m. my lord. I'm going to put your lordship.
Milord,
You can't-
I think the same.
না, আমি একটা affidavit টা হয়।
আপনি কি MD
Keep
sponge?
হ্যাঁ।
Milord, same order. My demolition is, Milord, today.
Oh,
Order
so-
given to me
Yes.
midnight. Hey, I'm sorry, not midnight. In the evening yesterday. Yesterday, order passed for demolition today. Statutory right of appeal is 15 days. And Milord, I have erected a 2 feet boundary wall to protect the land. I am Milord Rashmi Metallics. I have a plant over there. Government has told me, you buy land, I'll give you some more land and you put up an industry. Now I protect the land. I put up a 2 feet boundary wall. Some local blackmailer, Milord, files a PIL. Milord, the Honorable Chief Justice, Milord, doesn't pass any order, only directs, Milord, the authority to consider. They consider, give me a notice under the act. I appear for a hearing and say, I'll bring everything to you on the 13th. Please give me one adjournment. Not done. 13th, demolition order plus possession order passed, given to me yesterday for demolition today. If your lordships, my lord, don't protect us, my lord, these are last industries. Somebody wants to set up an industry in West Bengal.
Give-
Milord,
But
may I-
please put the other side on notice. I
Yes,
will
Milord.
not take up any of the matters without the other
No,
side.
Milord,
to
I'll
the
Let me
government
make it
pleader,
very
to the
clear.
Milord,
government
I
pleader,
will,
my lord.
may I prefer three things. Number one, Milord, is leave to Milord obtain tender AST number for Milord filing. Milord, we'll file in
That
the
we will
department.
That
Leave
we
to
will
move unlisted at 2 o'clock and we'll inform the government leader that this is happening. I'll personally tell him that we are moving at 2
Yes.
o'clock and your lordship has permitted
Yes.
us.
দুটোই দুটোর সময় fix
My lord, leave may be granted, my lord. This is, my lord, unaffirmed copy, my lord. So I'm
একটা
just
সাপ্লিমেন্টারি
reading the
লিস্ট
petitions
করুন
affirmed.
দুটোর সময় সাপ্লিমেন্টারি লিস্ট দুটো ইনক্লুড করুন দুটো
I'm grateful.
Allow me one permission. Madam, this particular matter, I am mentioning before you from the 18th July. But it's not fixed. The affidavit in service and affidavit in reply has already been done. This is the in a final hearing that your lordship 4 to 5 times I have submitted before
Where
your
is the
lordship.
file?
File is here.
Shantanu,
And the
take
running list on
Akshay,
20th September, list serial number is 341
in the
was-
supplementary list.
in the supplementary list.
So it's appearing in the list. What is the difficulty?
Difficulty, sir, madam, this is not hearing, but one matter has been fixed. Today, 2022, in 2023, but this matter is not.
It is running in the list. All matters are not fixed at a particular time. If it is in the supplementary list, it will be taken up. Several hearing matters are pending, can't help.
My lord, with your lordship, my lord, leave, my lord, I'm mentioning upon notice. My lord, the matter is running in the monthly list as item number 924. My lord, I filed, my lord, several CAN applications. I am the inoccupants of that area. My lord, what has happened? The promoter has filed a writ against the government. There is an existing dispute between the promoters and the government. I am, my lord, occupying area. My lord, I have not made a party to the writ. Asking for leave to be a party to the leave to the writ. I filed, my lord, the CAN applications, 9 CAN applications, my lord, but this CAN applications appearing in the monthly list as item number 924. My lord, I'm praying for upgradation.
Writ petition is appearing in the supplementary list.
I'm not in monthly list, my lord.
That is also in the monthly list.
Monthly list item number 924.
So you want the application to be tagged with the writ petition, isn't
Writ
it?
petition and my lord, let the matter, my lord, appear in your lordship list, my lord. In
Wait,
my lord, 10
give the
days,
number,
my lord.
please. Give the number, please.
Saying for my lord, upgradation. I mentioned my lord, all the CAN applications that are filed. Grateful, my lord.
Yes,
This matter was supposed to, my lord, appear today, my lord, as per my lord's, on 22nd September, my lord, 2000,
not appearing.
not appearing.
Give the number.
Monday,
My lord,
second page. Yes,
my lord,
grateful.
kindly to mention your lordship, item number 301, your lordship. My lord, this is in regards to a tender work, your lordship, issued by the Eastern Coalfields Limited. My lord, we are working in a precarious situation, your lordship, and we have made several representations to the ECL, my lord, but they are forcing us to work in those conditions, my lord. My lord, the lives of my workers are at stake at this point
How,
of time.
how does this court have determination?
My
This
lord,
is a tender matter, a service matter.
not so, my lord, tender works has been issued.
Tender matter, this court doesn't have determination.
But it has been filed in this.
Please find out.
Wait, my lord, I'll check up, my
If
lord.
it is wrongly filed, I'll release it. Please find out.
Grateful, my lord.
Include. Hearing on September 22. আজকে, take it in তাহলে normally আসবে।
Day list item number 1.
But I appear for the petitioner, my lord.
I'm for the
Let me
sought
decide.
to be added respondent. I'm
Lord, this
led
is
by
my
Mr.
affidavit.
Otis Kumar Biswas. He is seriously ill and he is bedridden, suffering from high fever.
You
Praying-
are asking
praying-
for time.
I'm praying for 1 week adjournment at least.
My lord, last week, my lord, last day, my lord, they paid for time and your lordship allowed the time. I have no objection, my lord, as he is the landed advocate sick.
Yes, I was about to say that. Have you heard the
Yes,
ground?
I am not saying that the affidavit I have submitted to your lordship.
Let this be taken on record.
Yes, as per your lordship directions, we
You are
have,
the petitioner.
I am the lead petitioner.
Please serve a copy of the affidavit.
I have already served. Already served, my lord. Things is, my lord, your lordship dispose of the lead petition directing the DLRO to hand over the possession pursuant to the order passed by this honorable court in 1999. My lord, kindly see page 9, your lordship order. In my affidavit, my lord, page 9.
You can see the order.
And my lord, the added to be respondent, my lord, they are saying that they are the fishermen and they took lease of the property. But things is, my lord, the order passed by the department, my lord, kindly see page 21. That was the order passed by.
The matter has been disposed of.
The matter has been disposed of earlier, but being aggrieved, I'm the added respondent, sought to be added
Not
respondent.
added.
In a disposed of matter.
No, I have being aggrieved with a order, as I'm not fully instructed in this matter,
Have a
your
separate
lordship.
writ petition to file.
A
Disposed
a
of-
mandamus appeal was preferred and a liberty has been given to file a addition of party. And in accordance with that order, an application has been filed as a CAN 1. And in respect to that, an opposition has also been filed and this has been received yesterday. And in this situation, my senior is seriously ill.
Please come back after vacation.
After vacation, kindly,
That's subject to.
otherwise we'll be
Opposition.
deprived.
Lord,
Can
Lord,
one.
give some priority, my lord, matter was disposed of, my
Affidavit in
lord,
opposition.
your lordship.
So there is no stay order, matter has been disposed of. You have no urgency at all, sir.
Now, urgency is, my lord, we are not taking the possession. That is the, we
is
have
no
the
stay.
property. We are the owner.
There is no stay.
No,
That appeal was contested one. No stay was there.
Affidavit in
Only
opposition
things is, my lord,
submitted by
the
the
appeal court,
petitioners
my lord, give liberty to the applicant.
is taken on record. Paragraph on prayer of the proposed intervenor, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th November.
Good.
Please you.
My lord, the affidavit in opposition be kept in the grateful, 30th November.
Thank you, ma'am.
Finish.
Item number 2.
Item number 2.
Yesterday, nobody appeared.
হয়তো এখানে জানি না।
Can 1 or can 2? None appears for the applicants. Stop, no accommodation is sought. Paragraph, it appears from the conduct of the applicants that they do not intend to proceed with the applications any further. Paragraph, in view of the above, the applications being can 1 of 2023 and 2 of 2023 are dismissed for default. Paragraph, there shall however be no order as to costs. Paragraph, in the result, comma, the writ petition being WPA such and such abates. Sole petitioner has died and no steps. Ordinance 35 itself. ABAD. Yeah.
Item number 3.
Item number 3, my lord, I am for the petitioner, my lord. My lord, the signature is online, my lord. My lord, I require one more week, my lord, to file my exception.
Will you come back after vacation?
No, my lord, only 1 week. Some mishap occurred in the family of the petitioner, that is why I require.
Learned counsel for that. Further extension of time to use the exception as sought. Paragraph, let the matter appear same heading on 16th October.
My lord.
Item number 4.
Please, your lordship, I am appearing for the,
For India, my lord, there is a direction for my lord, report, my lord. I pray for 1 week's time.
my lord, I very oppose, my lord. This is going on for quite a long time now. My lord, they twice they agreed. They first agreed to one level, then they agreed to a reduction, we agreed to that. And now, my lord, since 1997, this matter, they have not even revised.
Lordship, last question opined that the report is necessary. Report is approved by the Ministry Delhi and also Ministry of Law. Only, my lord, is to be affirmed, my lord. It
My
will
lord,
take
let them pay,
week
what
session.
the last agreed without prejudice, and let them, my lord, this cannot go on. Since 2097, they are not revising. They have already agreed twice on 2 occasions. Now,
Good amount.
Lordship,
Pay the admitted.
my lord,
amount.
admitted the problem
my
is
lord,
that
only 1 week, my lord. Report is, my lord, approved by the Department of Law and also the Ministry of Law, my lord. It will
My
only to affirm, my lord. Lordship,
my lord,
directed
this
the
is going,
report, my lord.
my lord, what is
Only
happening,
1
this
week,
is
my
a
lord.
charitable trust, my lord. They are on rent. 1997, since 1997,
They're not paying.
no, they are paying they are not revising. There was a 2 meter, the central government PPWD rent,
The current rent is being paid.
that is, the
Continuous
current
paying is
rate,
going on.
they agreed first to a rate. Thereafter, they said, no, that is higher. We will agree to a lower rate. My client agreed to the lower rate. They said, we'll pay. What about the interest? We said, if you pay within such and such date, no interest. Thereafter, suddenly they come and say that the government is not approving. Yes. My lord, this cannot go, this cannot be. A government organization has to pay reasonable compensation.
Let learned counsel come back to the report. If the government
Lordship.
doesn't approve, the court will pass an order.
Lordship, Lordship. Lordship, may this direction be peremptory, my lord.
No further adjournment.
Lordship.
Let the respondents seek further extension of time to submit the report in the form of affidavit as sought. Paragraph. As a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 13th October.
13. May retain its possession, my lord.
It will, it's a contempt application. Yeah.
Lordship.
Oh, no, it will retain, hopefully. New motion.
At number 5.
Madam, for the state respondent, your lordship directed me to submit the demarcation report. Madam.
Yes.
I'm submitting the report. Madam, it's not running well, perhaps.
You have
Madam,
served a copy?
I'm serving the copy. Your lordship can, your lordship can dispose it of now itself. Not your lordship can dispose. Are the demarcation? The lordship can see. Petitioner and other officials who are present.
My lord, may I cut short? I was sub notice, I was present, I am satisfied with the demarcation. The report has been filed, I have got the map which was required by me. Now everything will is purpose, my depreciation will be disposed of in this way.
Let a copy be given.
Nothing further to adjudicate.
No, nothing to be adjudicated, because further adjudication, my lord, if my name is not being mutated, then again I have to come.
That's a different issue.
That is a different issue.
Let a copy be given to us also. Let us see.
The matter is disposed. তুমি KMD কিছু করনি তোমার
আমি কি করিনি আমি দেখবো না
The state is angry on the KMDA. Please serve a copy.
Just is my
ও দেবে না আমি তো কিন্তু আমি জেরক্স করে নেবো
না
দিচ্ছি দাও
তোকে দেবো না, এটা হতে পারে? তোকে দেবো না, এটা কোনোদিন হতে পারে? যতই তুই আমার সঙ্গে ঝগড়া করিস
Demarcation
না কেন,
report along
আমি তো
with
তোর সঙ্গে ঝগড়া করি না।
sketch map submitted on behalf of the state respondents is taken on record. Paragraph, it is submitted on behalf of the state respondents as well as the petitioners that the plotting question has been demarcated and demarcated in presence of the petitioners and a sketch map prepared to that effect.
আমি ভারতে আছি দিয়ে দেবেন ম্যাডাম
The petitioners have no grievance with regard to the said
টিফিন টাইমে
demarcation.
দেবেন
Paragraph, in view of the above, nothing further remains to be adjudicated in the writ petition. And the same is accordingly disposed of.
Dismissed.
Urgent certified website. আর কিছু হবে না?
Nice to have.
At number 6.
Lordship, 6. Item.
6.
Lordship, I am the petitioner.
And I am appearing on behalf of the intending.
Milord, I am the petitioner, Lordship. Lordship, after the read application, Milord, the respondent of 3, Milord, filed the opposition. And subsequently, I filed the Milord reply. And Lordship, the government report has been filed. Subsequently,
There is an intervention application pending, I think.
Lordship,
My
Lord,
my
please let me first. Lordship, thereafter, Milord, respondent of 3 filed another opposition, adding some documents. It is very much
I
necessary.
propose to deal with the
That's
intervention
why-
application first, not the writ petition.
Okay.
Have you received copy of the application?
No.
Can one?
Can one.
Mr. Bottabal, you have received a copy?
No.
Can one did not serve?
Wait a minute.
State को दिएছি
Right.
No, I have not received.
can one আমি একেও দিয়েছি স্টেট কে দিয়েছে I guess. মানে my affidavit of service is clear.
Why you are not serving the notice? As on when you mentioned, other side was there, Milord. Yesterday,
You respect my lord, whenever I try to give the notice, copy of the
ওদের অবসানটা
so until the court passing of the order and not.
Let me, my lord, I am drawing your lordship's kind attention to page 23.
Give me a minute, please. Where is your intervention application?
This is the application, my lord. Those were the unfortunate depositors of the Proag group of property. According to us, my lord, this property is belong to Proag group of property. Now, my lord, Honorable Justice Manjula Chendra and Honorable Justice Lordship Vidan was.
Are you ready for the hearing of this intervention application? Are you ready for hearing of the intervention application?
No, Lordship. I am applied for the certificate copy, some documents which was annexed by the Miller's second opposition of the resolution.
That is the writ petition, sir.
Yes.
I want to deal with the intervention application. I am not on the.
I have no interest regarding the intervention. Miller.
So let this be allowed. Let the intervention application be allowed by consent of the parties.
Lordship, no one appear of the other Miller, the government and rest of the three.
We have no objection.
I have no objection. But my Lordship kindly allow me sometimes required because this second opposition some documents.
Asking for time in the writ petition, isn't it?
Yes.
So let us go a little ahead and let the intervention application be allowed. I'll give you some
As your
time.
Lordship, I have no objection. I have no objection.
Jan 1 of 2023. The
Addition of particular person.
applicants the applicant seeks to be added as a party respondent to the writ petition.
Additional but second addition.
এইটাতে আছে
On the ground that they are necessary and proper parties herein, and any order passed in the writ petition shall affect the interest of the applicant. Paragraph, by consent of the parties, comma, the application is allowed. Paragraph, the applicant be added as respondent number seven in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Can such and such is disposed of. WPA order করুন. On prayer of the petitioners, the matter is adjourned. Paragraph, let the petitioner, the comma, the matter is
Lordship.
adjourned. Yes.
Lordship.
Will you come back after vacation?
After vacation, Lordship, liberty to mention. After vacation.
I'll fix a date.
After
I'll
vacation.
liberty to mention. I'll
Milord,
fix a
I have
date.
already applied for the certificate copy of the documents. Original certificate copy. I have not.
I'll fix a date after vacation.
After vacation,
Yes.
liberty to mention.
Why liberty to mention when I fix a date?
After vacation.
Let a copy of the writ petition be served up.
Yes, yes. ওখানটা land যেখানে cost title amended accordingly. তারপরে the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file
After vacation.
in course of this day.
Lordship, the list November 15 was open. 16.
WPA te করুন. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th November.
Instead of
In the month-
November,
Yes.
I have some problem, my lord, because my daughter's marriage day.
Oh, so when can you come back?
My lord, in the first week of December, my lord.
Monthly list of December.
Month-
Monthly list of December? Wait.
Yes.
In the monthly list of December 2023.
Lordship, I'm obliged.
Next. Please serve a copy of the writ petition in course of this.
Yes, yes.
আপনি নিয়ে নিন, আমি ক্লার্কে বলে দিন, আমি ক্লার্কে বলছি।
Item number 7.
শুধু পিটিশনারকে দিলে হবে আমাদের? I am for respondent number 10 and 11.
My lord, on the other day, my lord was pleased to call for a report from the state authorities.
Yes.
Well, that report has been served upon us. From that report, my lord, it appears that initially an acquisition proceeding was initiated, but subsequently no step was taken on the basis of this.
May I just clarify the situation? It's a coal block, namely Trans Damodar sector coal block. It was allocated in favor of the West Bengal Mineral Development in 2006. Subsequently, production was commenced from 2012 and it continued till 31st of March 2015. In the meantime, the order of the Honorable Supreme Court came into effect, thereby allocating all the coal blocks which were allocated by the Ministry of Coal through state dispensation route. Because the Honorable Supreme Court held that the central government or the Ministry of Coal, they do not have the power to allocate any coal block bypassing the Coal Mine Nationalization Act. Because in terms of the Nationalization Act, only the central government company, they are entitled to get coal block through state dispensation route. But in 2008 or something, a notification came. By virtue of that notification, it was incorporated that the Ministry of Coal may allocate coal block to state government company. This action was challenged in 2012 in a landmark judgment, Manohar Lal Sharma versus Union of India. In that matter, the Honorable Supreme Court deallocated the coal block. Now, when the process, the mine was developing by mineral development, at that point of time, the land was, partial land was acquired by the state government and rest of the portion was directly purchased by the mineral development. In terms of the order of the Honorable Supreme Court, it has been deallocated and now it has been allotted to Durgapur Projects Limited. But still the pre-mining activities is going on, mining has not been commenced. In such situation, the writ petition has been filed claiming that we are the owners of the land whose land has been acquired. But so far as the acquisition proceeding is concerned, well, while those land was acquired, compensation was paid to the landowners. And on that land, mining was conducted.
Where are those documents?
My lord, may I now submit? My lord, my learned friend is partly correct. My lord, the operation is still going on at the instance of the DPL. My lord, Lordship directed the state government to file a report. From the report, it appears that, my lord, before that I should mention, the matter was taken up on, my lord, 25/8/2023. My lord, there is some mistake in this order. The land has been subsequently vested, that has been recorded, but this is not correct. My lord, somehow, my lord, what happened? The DPL authority is extracting coal from the open mines. That open mines, my lord, has been acquired. But, my lord, so far the soil is concerned and, my lord, the drainage system for passing the water is concerned.
No.
That has been, my lord, started in our land without initiating any acquisition proceeding.
But underground has
To
not
that,
yet started.
to that, what I am on,
Open blasting is
report,
going on.
in the report filed by the, my lord, block development officer, it has been categorically stated that the acquisition proceeding was started, but as per official record, no further action has been initiated thereafter. That has been stated. Now, my lord, the DPL authorities should submit another report stating that how they are occupying our land.
No.
That will solve the entire problem.
No, my lord, we have not filed any report. What report?
My lord, let them file a report. That so far the report filed by the state government, my lord, it is appearing that no further proceeding, initially proceeding was initiated.
I think it requires to be heard on affidavit.
Mineral development is not.
Yes, yes, affidavit.
Here, they have nothing to say.
So Lordship can expunge the name of mineral development because
Let it
after
be
deallocation, for a period, mineral development was acting as the mining agent of DPL.
Yes.
That contract has been expired. So we, as on date, we are not the
Milord,
not the proper party.
the DPL authority is in picture. My lord, on the earlier occasion, my lord, when it was taken up, I did not sub copy. But my lord, since he was a
But my
party to
lord,
the proceeding, to this writ proceeding, my lord directed.
Yes, your Lordship on.
That is why my lord
25th of July
directed
to serve copy.
sub
upon
copy.
mineral
Accordingly, I sub copy upon my learned friend. My lord, let his name be expunged, but
My lord, lordship kindly direct the DPL authority under what authority of law they are using our land.
We have came into picture after 2015, sir. Prior to that, another
Whatever
agency
may
was
be,
there.
they are utilizing our land.
No, after 2015,
In
we
the-
have not,
in the
we have
report-
nothing to do as yet.
Then mineral development.
Let me call for affidavits in this matter.
Yes.
Lord,
The private
I-
respondent cannot come up with a report. An affidavit needs to be.
There is no private.
Private
There is no
respondent
private
not there.
process.
Durgapur Project Limited.
Government company.
So will you come back with a separate report?
No,
My lord, my lord, kindly tell.
affidavit, it will be decided upon affidavit.
Report in the
No.
form of affidavit.
Yes.
Because one report is already there, the state has filed.
My lord.
Please come back with another report in the form of an affidavit.
Yes, yes. Well, we have not yet started anything. My understanding is saying.
Let them
everything.
say.
After 2015, we have came into picture as per order of the
Let
Supreme Court.
them
Yes,
say
well, I'll
what-
come up with an
Yes,
affidavit.
yes.
You're in possession of the land.
Yes.
Yes. We are,
They are utilizing our land. Now they are saying.
now, Milord, already district magistrate has already, Milord, started initiation for rehabilitation. ROR was approved, everything was there. My learned friends, Milord,
What my
perhaps is
learned
not
friend
acquired.
is saying, look, this is there.
For
nothing
compensation
appearing
and
on the
rehabilitation
report
is
file
concerned,
hearing.
the district magistrate had already taken steps.
Where from he
The
take?
land which was
And-
acquired
Yes.
when the mining was conducted by mineral development and the purchased land, that portion we have handed over to DPL.
Yes, only that portion.
There is no dispute with regard to that
Yes.
portion. Learned counsel,
Ma'am.
says beyond that portion, it is
Plus,
being
if-
utilized.
If anything is conducting beyond that, plus I believe mineral development is not a necessary part.
Yes,
You have to
yes.
Kindly expand
I'll
the
explain.
name. Yes.
But
No, that's okay. Mineral development is not.
Lordship
necessary
kindly
part.
correct this one, my lord, earlier part of the order.
But
That
Milord,
land has been subsequently vested. This is not.
Milord, beyond that, Milord, we have nothing to do as yet. My latest friend says everything.
May I have your lordship kindly?
Yes.
May I have your
Go,
lordship?
go.
May I have your lordship's kindly?
Leave. Oh, leave.
My lord-
I'm not-
After vacation,
You have to say something.
Yes, yes. After vacation.
No, before vacation, it can't.
My lord, my learned friend wanted it will never be heard.
inadvertent error
The
has
file
led to
should
the
go
order
before-
passed on
What my latest friend will,
August 2023.
what my latest friends will do?
In the
জায়গাটা তো
second
নিয়ে তো
paragraph
কালকে
of the order,
ওখানে বলে দিচ্ছি বন্ধ করে
the
দেবে সব
sentence.
লোকজন।
inverted
করে
comma
দিন।
open borrow,
বলে
The land has been subsequently vested. The land has been subsequently vested in inverted comma closed. Be deleted. Paragraph. The department is directed to incorporate necessary correction.
Well, kindly
according-
record, Milord, that without.
Paragraph, this, I'm dictating an order, sir.
I'm
please.
dead.
This paragraph, this order be treated
এটা
as part of the
CSC
order
নয়।
passed on 25th August 2023.
বুঝলো বন্ধু? CSC
Paragraph.
নয়।
It is not in dispute that the West Bengal Mineral Development Trading Corporation Limited has no role to play in the
কত হচ্ছে? My lord,
subject matter of the
my
writ
junior is
petition.
here, my lord, I'm coming.
Accordingly, the name of the West Bengal Mineral Development Mineral Development
And Trading Corporation.
and Trading Corporation Limited, it's written mining development here.
There is nothing wrong
Comma
with it.
being the ninth respondent in the writ petition, comma be
No,
expunged.
mining development.
Paragraph cost title of the writ petition be amended accordingly. Paragraph. It is submitted on behalf of respondent numbers 10 and 11.
10 and 11.
10 and 11 that mining operation is being carried on.
Carried out, but without, but my latest contention, the beyond the area of occupied, that has not been.
That mining operation is being carried out only.
But not
in
under
the-
count, open blasting is. there.
Only in the area allotted to the said respondents
Open blast.
and not beyond as alleged by the petitioners. Stop Learned Counsel for respondent numbers 10 and 11 seeks to submit a report in the form of affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 28th November. 28.
Or maybe some more time.
Some more time.
আরে পুজোর ছুটিতে কি কাজ করবে?
Pujo is 7 days. After that, you have time.
All right.
Mining. Mining. না না ওখানে মাইনিং আমি যেটা বললাম সেটা বললাম।
My lord, kindly record that only open casting is there, not underground.
Open
Mining is going on at the
Open
open cast
casting,
portion, not
not
underground.
underground.
জয়ন্ত
ওই যে ওইখানটা একটু-
যেখানে মাইনিং অপারেশন ইজ বিং ক্যারিড অন বললাম ওখানে
At the open cast
at
portion.
the open cast portion
Not underground.
and not at the open cast 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 portion and not underground.
Grateful. to
Next,
Number 8. My lord,
yes,
my lord, this is the second round lead.
it's the day for the
Here.
No, pertaining to the, which is now called pertaining to the open cast area and not underground.
My lord, this is the second round litigation. My lord, matter was moved before my lord on 5th of September 2000. At the time of hearing, my lord, I categorically read out my lord's order. My lord, to sort the my lord order, kindly see page 124. My lord, observation was 1. Having considered the submissions made by the learned counsels appearing on behalf of the parties, this court is of the view that as the petitioners stand on the same footing as the other co-owners of the property in question, who are granted enhanced compensation in terms of the order passed in CO 15853 W of 1995, the petitioner are also to the same benefit. This was the my lord's observation.
Yes.
I served my lord's order. The collector, by his order, without any date, after 7 months, my lord's order, after 7 months from the date of hearing, stated that hence page, my lord, 133.
Yes, yes.
Ordering portion I am put. An amount of rupees 16,84,000, including solatium as dignital dues, was paid to the awardee, though compensation is to given to land to loser under the pale of the DI Act 1939, sans solatium and 12% additional compensation. Therefore, in light of the above, the claims of the petitioner for additional compensation at the rate of 12% over all the enhanced amount of compensation are not illegally tenable and lost the proprietary reasonableness. But this is the absolute arbitrary and unfair judgment. My lord, kindly with the written notes of argument. My lord, kindly see with list of dates.
My lord, already I have the not in the form of the.
You want to come back with the report?
Yes, my lord, because as already we have come, I have, my lord, with the report, in the report, not in the form of evidence. My lord, if your lordship will, desire to form, I will give it in the form of.
Can you hand over a copy of this report to the petitioners?
Yes, but I think your lordship, then I can, as because my lord, it depends of India Act, there is a defense of India Act, there is no any provision of giving the solution. But that is not, he is not entitled to it. Only this,
But what about the other co-owners?
other things, my lord, was.
And other-
My lord. Only 12%.
No, I am after his term. We was,
For that Defense of India Act, my lord, there is any provision of pay additional compensation of 12%.
Let the report come on record. Let the report of the state be on record.
there are Supreme Court's judgment. And only see the judgment of the Supreme Court. They,
Have you served a copy to Mr. Dey?
notes of, one copy served, notes of argument I am.
My lord, after report, if you
My lord.
hear the matter, then, my lord, that will dispose of this matter, your lordship can dispose of this matter, my lord. এই রিপোর্টটা নিয়ে যদি কিছু বলার থাকে বলো, 7 দিন বাদে আসো, এসো, এটা তোমার কিছু করার নেই।
Since
I know,
1945,
my lord, only for that.
since
reason, my lord,
1945,
I- as report has come, my lord, I am bound to go by this report.
my lord, kindly one, page 81, my lord, kindness.
Yes,
Page 81.
yes.
This order placed by the state government at before the Honorable Supreme Court. Order, my lord, delay condone. We are satisfied that the High Court is right in holding that if the degree provides for payment of 12% interest, whether justified or not, the executing court cannot go behind the degree. This is the order of the Supreme Court. How the collector, without his jurisdiction, and he is here, the DI Act, but his superior is stating that. Manner kindness. Yet about it. Order.
My lord,
Manner kindly see, page 54. He is stating that the DI Act,
My lord,
DI,
Since the state wants to come back with the report, let the state submit the report. Please have an advance copy so that learned counsel can deal with it.
or my lord, this report, I hand it over, if he wants to say anything, my lord, I the report
no,
and hand it over.
whether it is applicable or not, my lord kindly.
My lord, as a report is, my lord, with my. So, my lord, I am always bound by the report, my lord, I must submit. according
And
to
have
the-
you received the copy today that learned
Yes, my lord,
counsel has
it's,
submitted?
Yes, my lord.
So
I
please
have-
go through the report and come back.
My lord,
Please go through the report and come back. Yes,
my lord kindly fix the matter on Monday,
not Monday, I have to fix a date.
by this month, my lord kindly.
Not this month, this is the last week, not possible. Affidavit of service. Paragraph, written notes of argument submitted on behalf of the writ petitioners and status report submitted on behalf of the respondents are taken on record. Paragraph, let the matter appear under the same heading on 10th October.
10th of October. My lord, may I
Mr.
pray?
Dey, please consider the contention.
My
of
lord,
the
I have
matter.
only point, my lord, otherwise, my lord, I have seen everything, my lord.
আরে
Only the
সুপ্রিম
report
কোর্ট
has-
জাজমেন্ট দিয়েছে তুমি
দাঁড়াও না,
ওটার
only for
উপর ইয়ে
this, my lord, only for that cause, my lord, I am. Yes. My lord, next matter, my lord, it next matter.
Item number 9.
এই নাও, next matter.
আইডেন্টিক্যাল ম্যাটার
এই নাও,
Similar,
next
similar.
matter.
একটা হলেই তো হয়ে যাবে
না, না, প্রতিটাই লাগবে।
ইয়েস এক সিমিলার ম্যাটার
My lord, I filed the report. Yes.
Status report. Oblan.
My lord, may I be permitted to this?
Have you received a copy? Have you received a copy?
ইয়েস
Status report submit now.
এটা
Status report submitted on behalf of the state respondents is taken on record. Paragraph, let the matter appear under the same heading on same date.
ওটা দে
They will all be taken up together.
হ্যাঁ।
All the matters will be taken up together.
Next 10. 8, 9, 10.
Same order,
10 also same.
on the service.
Affidavit of service I plus. Huh?
Huh? Same way, same.
9.
Sir, 10
না ওটা একই identical matter. হ্যাঁ,
Ten
এইটা
submit separate report.
এটা না দিলেও তো
Lordship, I appear on behalf of the respondent number 6. We have already filed our report
In which matter?
in item number 10.
Is the
Aye.
state submitting a separate report in 10? Mr. Shankar? Please concentrate, sir. Are you filing a separate report in 10?
I'm not happy. I'm 8 and 9 on.
And Tony Mr. De. His senior is Mr. De.
That I know. Yes,
8 and 9.
8 and 9.
in 10 you're not appearing. In 10, you are appearing in 10.
I'm appearing for the respondent number 6, your lordship.
That's the land acquisition collector.
No, your lordship, HITCO.
হ্যাঁ হিটকোটা কোন ম্যাটারে বলছো হিটকো তো নেই
There is no HITCO in 10. It's the land acquisition.
তুমি
collector.
দেখো
My mistake.
না আমাদের
So who is appearing for the state in this matter?
8, 9, 10. 10 এর নামটা বলুন বাসন্তী yes মানে 10 is বাসন্তী same identical matter.
I'll regularize Mr. Dey's appointment in 10. Affidavit of service, none appears for the state respondents. Please serve a copy of the writ petition to Mr.
already I thought
10 টা আমাদের কাছে কপি নেই আমরা 9
Affidavit of
আমরা
service
8 and 9 এর হয়ে appear করছি দিনের কপিতে মাইনর আমাদের রেগুলারাইজ করে
Copy of copy service and direction will.
সার্ভিস
Separate, let the matter.
Service.
Let the matter appear under the same heading on same day,
তিনটে
10th October. Please
Eight.
serve a copy in 10
10
because I am regularizing Mr. Dey's appointment.
10 তোমাকে
Next.
At number 11, that I appear for the KMD in this matter.
On the respondents to file a report. We have received your lordship, total 3 reports. One is by. The KMD's report is awaiting. Yes. They are saying they're not concerned with this. They are not? They're not concerned with this.
We are not
See the copy of the report? Yes, we have received the copy of the report filed by the KMD. Your lordship kindly have a look at that. You're for the housing board?
My
No,
lord,
lordship, I am for the petition. If your lordship sees paragraph 5 of their report once. Respondent number 6? Yes, so you are appearing this matter.
7, 8, we are 7.
So 7, 8. There is a report also of respondent number 6 also, but this is. You don't intend to use an exception to the reports. No, lordship, they say if your lordship sees it's in my favor only. If your lordship sees paragraph 5, give me a minute, please.
Of course, in their favor. The writ petition grievance has been ventilated, as I understand, my lord, against the HITCO.
In paragraph, they say that the land in respect of which relief has been claimed in the writ petition are neither acquired in favor of the KMDA, nor the same falls within the Calcutta metropolitan area as opposite. The KMDA refrained itself from making any comment. So the acquisition part goes.
This is for the state to answer.
Now, if your lordship sees respondent numbers 2 and 3 is appearing for the state. Mr.
Paragraph 6 of my report, lordship kindly have
I've
it.
seen that, I've seen that.
See,
For the
6.
state to
Yes.
answer, my lord, there is no.
You are appearing for the HITCO? If your lordship sees the affidavit of the respondent number. The primary grievance is against HITCO.
Yes, because Madam HITCO had written certain letters on the basis of the documents so available with the state. But if there is no acquisition, then Madam, the
There is
natural.
no bar in issuing no objection. LIUT.
I believe so, ma'am.
I think
Well, I cannot-
NKDA
I
should
cannot-
have been made a party here.
Who?
Because NKDA, New Kolkata Area Development Authority.
Your Lordship, we
Why
have
is
made
NKD
Because the area,
Officer, why would we
instruction
make them
that-
a party?
that's what I've stated in my
The
paragraph.
development authority for that area is NKDA, not KMDA.
Not came.
So, my lord, I'm not representing NKDA.
No, but if the land has not been acquired at all.
Then, my
there's no
lord,
question of NKD.
whatever is,
Yes, that's
whatever
what
be
Lord
the
Shah is saying.
consequence, that consequence has.
If your Lordship
But,
sees, there's a report by
I
the
did not
respondent.
find Mr. Dey. Yes, where is Mr. Dey?
But, my lord, HITCO cannot make any further submission, that I am making it very.
We also made our position clear.
We have filed our report, we will not travel beyond our report.
Now, the question boils down to the fact as to whether there has been any acquisition at all.
If
If
your
there is
Lordship
no
sees,
acquisition,
we have said that there are letters on record where they have said that it has lapsed. Now, in
yes,
the report also, they say we have not complied with section 9. They have in fact not complied with any of the provisions of the land
it
acquisition.
doesn't remain, yes.
Nothing remains
But
and
I
writ
believe you
petition
have to
should be
hear
allowed.
the state's council for that.
Then kindly keep it on Monday, your Lordship, so that Tuesday, Monday, subject to your Lordship's convenience.
Whether acquisition has been made or not.
But that's the respondent number 1, 2 and 3, they have already
by
filed a
the
report.
state. There's already a report by the state.
Absolutely.
Yes.
It
So no
says so.
further report is necessary.
Absolutely, your Lordship. If your Lordship wants the respondent number, wants to hear respondent number 5, I think.
The state.
The
Yes.
state. Then your Lordship, no one is
State
there.
appears to be the answer to the respondent.
Respondent
Then
number
your
5 is
Lordship,
housing board.
Tuesday then?
Respondent number 5 is housing board.
Okay. You want them to be here?
No,
The
the state has to answer.
Oh, your Lordship, is very well. No, not 5. They are not on 5. They are on 1.
Will you come back on 5th October?
Well, can it
Kindly
be
fix it next week, your Lordship. Kindly take it up next week.
Next week will be difficult.
any
Come
day
back on
apart
5th.
from 5th October, madam?
Yes,
Any day apart from 5th October?
apart from 4th.
Yes, yes.
But in the prayer of the writ petition, what the relief they are seeking to declare one LA case, they have to have lapsed.
Yes.
Lapsing of the acquisition proceeding has been
And that
cleared.
only state can answer, we will
Only
not
the
answer.
state
But
can.
that has already been answered by respondent number 2 and 3. That your Lord, and there are letters, your Lordship. There are letters which we have annexed to the writ petition. If my learned friend says that they
The
are,
acquisition has not been proceeded with, 11A,
Absolutely, it
it
lapses.
lapses automatically.
and if the KMDA says that we are not the
Section
necessary,
nine
Whereas
then
matter
we should
is-
submit any
So far as
submission
matter
regarding
HITCO
whatever
is
they have
concerned, madam, it's a case of acquired knowledge.
You can assist.
We do not have any first-hand knowledge. Only the state can answer.
We can assist the court.
Lordship, if my learned friend has a problem on 5th
And
of
why
October,
is a no objection required from the HITCO for construction?
yeah, your Lordship, the department is asking for it. That's why we have mentioned in our writ
Which
petition.
department is asking for it?
I'll just.
Planning authority.
Your
It
Lordship,
is still a
it's
planning authority.
one
It is still, I
25.
believe it is still a planning authority. Madam, subject to correction, I will take instruction from my plan.
If your Lordship sees page 125 to my writ petition.
Anyway, please come back. Please
Yes,
come
yes,
back.
certainly.
Your
Not
Lordship,
then
instead,
we
can it be on
Sir.
6th of October instead of 5th? Because my learned friends are difficulty on 5th.
Fifth is typical.
You
You
have a
want it on
difficulty on 5th.
On fifth.
You
On
want it on
6th,
6th?
then it
Very good, very.
6th of October.
I take your lordship's kindly, madam.
I'm great.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th October.
If your Lordship, it can retain its position.
Hopefully.
I'm great.
It's a new motion.
Number 12.
I am for the petition, MLA.
I don't have recorded that we have filed.
Yes,
I am appearing for this filed affidavit today.
আমি
the
কাজ
report today. My lord has
Oh,
recorded.
Omlan, এর আগেরটাতে affidavit, report in the form of affidavit submitted on behalf of the KMD is taken on record.
KMDA, 7
My application, my lord, last occasion, your lordship,
Or stop.
private respondent appear, my lord, private respondent appear, my lord.
I'm appearing for the state respondent.
My lord, my allegation is that, my lord, page 30,
Who's
30, my lord.
appealing for the state?
That's why I'm appearing for the state respondent.
Your appeal?
This one. My lord, page 30, my lord, 30, my lord.
What is the matter about?
Matter is that, my lord, the private respondent, my lord, in encroach, and making construction in the vacant land of the PWD road, and my lord, obstruct my ingress or egress. My lord, my land is just beside the roadside, my lord. So, my lord, they have constructed. My lord, I have wrote a letter. Kindly see, my lord, page 30, annexure P3, my lord. The representation was made, but till date, my lord, they have not taken any steps, my lord, against the best practice, my lord. It was duly served, my lord.
This is a report from BLLR. This is 2021 report.
This is
2021 report. This has been filed in 2023. This writ petition. This is 2021 report. Kindly see.
My representation is 4th April 2023, my lord.
Very good.
Yes, they have given an opportunity of hearing. Both the parties, they will satisfy. After pre-inquiry, my lord. Physical verification in my presence is required, my lord.
Yes, how does this help you?
Yes, ma'am. Kindly come to the second page of this report. There is no acquisition, nothing. Whatever he is submitting.
Not, I have not coming any acquisition, my lord.
That's
They have acquired making construction over the PWD road.
Before
Yes.
Before 144 court, they are submitting that this land has already been acquisition. Malad, now they are saying that this land belongs to a particular department.
PWD road, my lord.
This is my land. Malad, it has been specifically stated.
They said that it's PWD road.
PWD road. Malad, kindly see.
And this is with regard to 63, Dag number 63 and 64.
Yes, ma'am.
This document relates to Dag number 63, 64. But the writ petition is the Jamboni Chilki God Road.
Yes, ma'am.
So this has nothing to do with this application.
They have
আপনি রাইট ইনফরমেশনটা দেখুন তাহলে বুঝতে পারবেন দেখুন
regarding
the petitioner claims to be owner of 63 by 85.
Yes,
my lord. The DD says so.
That is not actually the subject matter of the writ petition.
Yes.
Subject matter is the road. Let the representation be considered.
Yes,
Being
ma'am.
given an opportunity.
That is my surprise, my lord. They have also given an opportunity, my lord.
Without
Yes.
very
Yes.
that be considered.
Yes, ma'am.
Respondent number 4, my lord. The executive engineer.
Assistant engineer has.
Assistant engineer. এটা একটু দেন
The petitioner, affidavit search. The petitioner claims to be the recorded owner of the plot in question and subjects that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard for the concerned authority on 4th April 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the private respondents have raised construction on their Rayati land and have not encroached any portion of the PWD road. Paragraph. Learned counsel for the state respondents submits that the
My lord, assistant engineer is not made a party, my lord.
party, yes, that the 12th respondent be directed to deal with the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the 12th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of which act line. একদম শুরুতে করুন, on prayer of the petitioner,
Yes.
leave is granted to complete the assistant engineer,
Yes, ma'am.
Jhargram division,
Yes, ma'am. Yes, ma'am.
Jhargram division, comma, public works department within bracket roads, comma, government of West Bengal, as respondent number 12 in the writ petition. Paragraph. The cost title of the writ petition be amended accordingly.
Deep level. They have communicated the decision within, my lord.
We are missing your lordship for last 2 years in criminal bench.
My lord, they will, my lord, communicate the decision within, my lord, certain time, my lord.
Yes,
They will communicate the decision.
not necessary because section 10 proceeding has to be initiated.
Yes, ma'am. Yes. Yes.
You have to adduce
Yes, sir.
evidence.
Deep.
Grateful one. Deep.
But initially, my lord, the writ application was moved on upon
Give me
notice.
50 minutes.
My lord, on last occasion, my lord, your lordship was directed to submit the report, my lord.
Number 13.
তিনটে আছে পরপর, হ্যাঁ? পরপর তিনটে।
এই নাম্বার
13, 14, 13, 14, 15.
হ্যাঁ, ওই যখন বাড়বো তখন দেখুন।
My lord, your lordship is already granted interim protection, my lord. My lord,
Yes,
and just I have only one submission, my lord.
But a copy
My
of
lord,
the report may be submitted to me.
in respect of, I am not relying,
But maybe it will sub upon me, my lord.
you have not served a copy.
no, my lord, I am not on this reply, my lord. So I know, my lord, he has to be replied to that. My lord, regarding the interim order or extension of interim order, my lord, only one line submission, my lord, kindly direct to produce any valid documents that he has any authority to occupy the railway land. And in this particular respect, my lord, our various courts, my lord, since from the Honorable Justice Jayanto Vishwas, Honorable Justice Devanshu Basak, Honorable Justice Dipankar Dotto, Honorable Justice Dotto, and my lord, the various judgment is there. My lord, they have no authority to occupy any land without any valid license.
My lord,
And my lord, I am relying just.
my lord, well,
one
let me say by
judgment
writ
which is-
application, let me
which
submit
is-
first, let me submit
which
first.
is-
My lord,
You want to use an exception to the report or you
my lord,
are?
I will be accepting the report.
You should have served an advance copy, Mr. Ghosh.
Yes, my lord, but my lord, regarding my submission regarding extension of interim order,
Be done, because you've served.
So,
the
no,
copy
my lord,
already.
kindly consider one thing, my lord, that is the railway development project. My lord, that is going on. And due to this interim order, my lord, Amrita Bharat Railway Development Station project, that is already stopped in respect of the entire, my lord, the Kharagpur railway station. And my lord, the honorable railway minister has come, and my lord, the various steps was taken for development of that project. My lord, the duty this on interim order that has been stopped, my lord.
This is not the my lord, the.
No, my lord.
Project
So,
of- we
question
are
of
the
it is a
authorized
first, it is
allotee.
a policy
Madam,
of the
my-
railway,
My learned
and my
friend,
lord,
lord,
it is
did
a
not know.
development project.
My lord,
And person they are unauthorizedly
not-
occupying.
we are not authorized, we are the
Unauthorized, it is a
licensee.
question of the
We are the
development.
licensee.
It is,
Interim order was passed
let
upon-
them, my lord, produce that they are licensee. They are claimed that they are the licensee. For this reason, they have occupied.
The report come before the court, it will be, the repetition will be dealt.
So, my lord, kindly consider that, my lord, it is a Amrita Bharat railway station development project. That is, my lord, already stopped. My lord, due to this interim order.
You should have served the report earlier.
extension, man.
They have taken time, my lord, for filing
So,
the
my
report 2 and 3 occasions.
You are
No,
not
no, no,
taking
no.
matter today.
My lord, that project, my lord, that has been come into force in the year of 2002,
Not your fault,
2022, my lord.
This is taken on record. I repeat, if you are in such a hurry, this should have come earlier. Interim order automatically will be extended because you are not ready to do.
So, my lord, that should not be the extended automatically, my lord. My submission is, my lord, kindly consider my submission prior to, my lord, extending the interim order.
Learned counsel for the petitioners seeks to use an exception to the report. ওটার আগে করুন। আচ্ছা না, ছেড়ে দিন। Learned counsel for the respondents vehemently opposes extension of the interim order. Paragraph. The interim order was granted by this court on 28th April 2023 and has been extended from time to time. Stop. Copy of the report has been made over to learned counsel for the petitioners in court this day. Stop. This day for which the petitioners seek to use an exception and the matter cannot be taken up for consideration today. Paragraph, since the interim order expires on 30th September 2023, comma, let the said order be extended till 30th November 2023 or until further orders, comma, whichever is earlier. Paragraph, let the matter appear under the same heading on 16th October. This side.
Well, 16th of the reopening day.
Yes.
No, 16th October, I said.
16th October.
Next,
Three matters, my lord, 13, 14 and 15.
same.
Same.
Mr. Ghosh is appearing in all the three matters.
Your Lordship, he is appearing in all the matters. The affidavit has been filed.
All the three matters.
I have already,
Application is being filed today.
Yes, Your Lordship, that has maybe gone.
already submitted.
Same order. And the interim order also expires on 30th.
Sixteen.
16.
Item number 16.
But I beg to appear for the Eastern Coalfield Limited, my lord. As per your lordship direction, my lord, I have prepared my report, my lord. I am filing this.
Lordship, I am for the petitioner, led by SUVRA Bhattacharya.
Yes.
SUVRA Bhattacharya.
Here for the ECL.
My lord, I am for the issue.
What about the Union of India? You have served a copy of the report?
Yes, we have served the copy, my lord. Advance copy has been served, my lord. And they have the copy, my lord. If they want to file an exception to that,
Yes,
or
sir.
if they want
Yes,
to,
seeking liberty to file an exception to the report.
otherwise we can proceed also, my lord, no problem.
None appears for the Union of India. Paragraph, report in the form of affidavit submitted on behalf of respondent numbers 3 and 4 is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. After vacation? Yes, after vacation. Paragraph, let the matter appear under the same heading on 1st December.
Month. DPF.
Number 17.
Last occasion, your lordship directed me, my lord, to serve the notice to the government pleader, my lord, because my lord,
There's a change of.
change, yes, my lord.
Have you served?
Yes, my lord, this is the, my lord, service, my lord.
regional কি বলেছিল বলুন? Acquisition তো করেনি। Acquisition করেনি।
I do not find anyone for the state.
Yes, my lord.
Mr. Sharkar is here. May I request you to appear in this matter?
Yes, ma'am.
Please serve a copy to me.
Yes, ma'am. In course of the day, my lord, otherwise. No, no, my lord.
What is the matter about?
Matter is that, my lord, kindly, page 43, your lordship passed an order, my lord. Without acquiring my land, they have started construction over my land, my lord. Your lordship granted stay for a limited period and my lord directed them to consider, they have considered and rejected. My lord, without assigning any reason, kindly see, my lord, the region order, my lord, page 50, my lord. My specific allegation is that, my lord, that land was without acquiring my land, my lord, they have started construction over there. I have also annexed all the photograph, my lord, they are not considering all that, my lord, and passing region order, my lord. আমি আমার স্পেসিফিক এলিগেশন যে তুমি আমার জায়গাটা acquire না করে কনস্ট্রাকশন করছো ওরা সেটা কনসেন্ট ফ্যাক্টরস আমরা
Mr. Dey, are you appearing in this matter?
no no
So let me regularize your appointment.
ওই যে সেই যেভাবে আমি ছিলেন বলো বলো সেই যে সেই আমার প্ল্যানটা একবার না করে কনস্ট্রাকশন স্টার্ট করেছে লিমিটেড স্টে দিল উনি
Mr. Dey, will you take instructions? Because it's a reasoned order.
Distributed among the patta holders. Yes, certain case number. কোনো রুটিনে আমার নামে পাটা আজ আমার নামে সব রেকর্ড আমার নামে সব আমি দখলে আমার ওনারা আছে বলছে না that is the malad that is the then malad report is come should come malad otherwise that is the vested land was vested land but that is no acquisition is there and
Will you come
vested
back
land
to report?
yes malad yes
None appears for the state respondents despite
no no written back
service of notice.
a copy video
Paragraph today was presented for regularized court and copy service direction link. Paragraph, the order passed by the additional district magistrate and district land and land reforms officer on
compensation দেয়নি
কম্পেনসেশন দেয়নি এলে কালেক্টর বলেছে আমরা দিইনি দিয়ে
17th January 2023 is assailed in the petition. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 16th October.
Yes. Well, your lordship can give me after vacation, because
Will you come back after
before, as because my lord, before vacation, that is the, my lord, we must know all the and other six, my lord. My lord, they are disturbing my position, my lord. Every day, my lord, they have disturbed. My lord, your lordship, grand my lord, status quo, my lord, then my lord, status quo. My lord, my, all record in my name, all record in my name.
Come back after before 2 days.
Yes.
Next.
Number 18.
18, I am for the petitioner, my lord. Last occasion, your lordship directed my learned friend, my lord, to take instruction, respond of 5, my lord. To
So I have
instruction.
not received any written instruction. I have got the
I'll
instruction, my lord. My lord. Your lordship kindly peruse page 44.
Yes, my lord.
This is the second round of litigation.
Who is sitting for the state?
State. Yes, sir. Last occasion, state was present, my lord. They have filed a report, my lord. They have already submitted the report, my lord.
সেই রিপোর্টটা আমাকে দেয়নি।
আমাকে দেয়নি?
No,
Report has not been submitted. That's why I'm asking.
no, that is
মানে সৌমিত্র বন্দ্যোপাধ্যায় মানে appear মানে প্রিয় বর্ষ
Mr. Parthapratim Roy and Mr. Guchai, they are no longer in the panel, I think.
yes, I think they are no longer.
মানে প্রিয় বর্ষ বটবাল মানে আর সৌমিত্র বন্দ্যোপাধ্যায় ওইটাই।
না না ওই যে স্টেটের হয়ে কি অ্যাপিয়ার করছে তারা প্যানেলে নেই কালকে রিপোর্টটা দিয়েছে
এটা কি প্রিয়ব্রত বটপাল ওয়াজ ফর দি মালা স্টেট
রিপোর্ট দিয়েছে স্টেটে
I led by
মানে স্টেটের রিপোর্ট কি আছে
স্টেটে বলেছে আমরা অ্যাকুইজিশন
my lord here what has happened
মানে your lordship I mean
I do not find anyone for the state. And the report is also not there.
yesterday মানে
no they have served you the report but it is not
Both the
before your lordship
responses directly to submit report.
my lord the main respondents are the railways
and I am here
whether they are willing to take this land or not well, that has to be ascertained over here.
and your lordship kind
The
and your
state's
lordship
presence is necessary. Where is Mr. Botobel, Mr. Bandyopadhyay? Where are they? Their presence is necessary.
my lord then I say
my lord kindly come to page 44 once
yes
well this is the stand of the state
the second
I'm
round
reading my lord
this is the second round of litigation
number
First
of times my lord the railways were not present my lord during the
came before your
hearing my lord were pleased to my lord send this matter to the this my lord special land acquisition officer my lord several attempts were made my lord to make service upon the railway authorities my lord they didn't appear my lord now this final order my lord will get it at page 44 23rd December 2022 this is observed my lord kindly read my lord from 1 2 3 4 as per available office 4th paragraph my lord there is a record of acquisition of the land mentioned in the petition and due to absence of the railway authority the question of acquisition remain unanswered from their part. The writ petition also failed to produce any document of acquisition. Hence, as per hearings available, it is appears that no acquisition was made from this office. So state is very clear that there was no acquisition, my lord.
And what is your grievance? Construction is made on your land.
Yes, my lord, they have illegally, my lord, or my lord, forcefully, my lord, they have taken the land, my lord,
my
The
instruction
railways.
the railways.
my instruction is your lordship kindly come to prayer page 21 let that prayer be allowed let there be joint instruction Well, they do not want to take anybody's land without paying any they have not taken anything it appears from the record let there be joint inspection we have not I have got specific instruction on this
আমাদের এই জায়গাটা এই তো এইটা রেলওয়ে লাইন
because the earlier occasion it has been found there is no acquisition records for acquisition.
So if there was no acquisition, my lord, then the land still
Railway-
belongs to me, my lord.
Railway is not there. That is why, my lord, we have taken specific instruction. Let there be joint inspection according to the prayer made by the petition. We do not have any objection.
Just let it be allowed in terms of prayer A
Yes.
upon submission made by the railways.
Yeah, my lord. Instead of keeping the matter pending, my lord, this will be.
Heard learned counsels for the parties. তার আগে none appears for the state respondents. Paragraph. The petitioners complain that the Eastern Railway has taken over possession of 40.5 decimals of land out of 94 decimals in RS/LR plot number 457, Mouja Alipur, Khutiar numbers 1179 and 1182, jail number 216, police station memory, district Purva Bardhaman, belonging to the petitioners.
And which is disputed by the railway authority.
Well, if they are
And
disputing,
as-
well, enter for a moment. Well, if they are disputing that they have not taken my land, well, then they should release the land. Well, when I am going to construct upon my land, they are obstructing.
This is
Either of the way he has to go, my lord.
Neither here nor there, my lord. This is a practically, this is a case of alleging some encroachment which cannot be decided by the,
No, this is not encroachment. This is my land. You are
That is
on
why,
the grab of my lord, taking my lord, saying that I have acquired the land. You are keeping custody of my land.
if a land is acquired, my lord, there should be, my lord, acquisition proceeding.
Yes, what is that?
That is not there. That is my.
That is, if that is not there, that the land still belongs to me. Let them have their one stand, my lord. এখানে আছে, নেন।
The
Joint inspection করতে বলছে।
petitioners have prayed for a joint field inspection to ascertain whether the said 40.5 decimals of land has been acquired by the Eastern Railway and in the event the result is in the positive,
Liberty to take steps in accordance with law.
the petitioners pray for a direction upon the Eastern Railway to grant compensation to the petitioners in terms of section 24 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Paragraph. Learned Counsel for the Railways, Railways submits, on instructions, that this petition may be disposed of in terms of prayer A. Paragraph. In view of the above, this court is inclined to hold
No,
that
Lordship, kindly record, madam, the rail has, according to the railway, they have not.
Kindly
imposition of-
record that. Kindly record that. That will benefit me.
Yes.
ওটার আগে করুন। Learned Counsel for the Learned Counsel for the Railways submits, এটা দিয়ে শুরু করুন paragraph, that the plot in question has not been acquired by the railways. তারপরে Learned Counsel submits, on instructions. দুবার
Only one line. My lord, only one line.
Second time Learned Counsel submits on instructions, railways to the.
My lord, only one line. If they have not acquired, my lord, I have the enter right to have my land, my lord.
Yes.
The law.
My lord.
Yes, that is the
That's
My lord,
law.
kindly indicated that.
Not
Because
the law.
they have guard wall, they have given a guard wall on my land.
You should have come with the document.
My lord, what
photographs.
documents? You should have the documents.
That is why
You are taking, you are having my land without granting any compensation. And then now you say that we have not acquired my land.
About the-
My lord, kindly indicate that, my lord.
This court is inclined to, in view of the above, this court is inclined to hold that no fruitful purpose shall be served by keeping the writ petition pending. Stop. The writ petition being WP such and such is allowed in terms of prayer A. Paragraph. If upon joint inspection, it is found that the land has not been acquired by the railways and is in possession of the railways, the railway authority shall release the land in
Deeply
favor of
obliged.
the petitioners and make over possession of the same
Deeply
to
obliged.
the petitioners forthwith.
Deeply obliged. Entire process should complete within, my lord.
Paragraph, the entire 2 months.
2 months.
The entire exercise shall be completed by the authority within 2 months from the date of communication of this order.
Deeply obliged.
Our report is ready, my put on a reach in time,
Is the bus
within 5 minutes, I am filing. Kindly allow me to file.
disposed of? After that, if you want to come back with the report, you can.
Report a copy আমাদের কাছে নেই।
My lord, he has served the copy upon us.
আমাকে দেয়নি। I have not been provided.
Request টা কেটে দিন, ওনার নামটা দিয়ে দিন।
She should serve a copy of the report to me also. That has not been served. পাবো না। But your lordship.
Next matter.
Number 19.
19, your lordship, I'm praying for not to the behalf of the petitioner.
After vacation. On prayer of the petitioner, the matter is adjourned. Your decision. Paragraph, let the matter appear under the same heading on 1st December. 1st December. 1st December.
Number 20.
My lord, I appear on behalf of the petitioner, my lord.
Lord, I appear on behalf of private respondent number 10.
My lord, in this matter, my lord, I am the respondent number 9. My lord, may I be granted leave to move in person?
Yes.
My lord, the proceedings have been drawn, my lord.
For the state.
My lord, the proceedings have been drawn pursuant to the order passed by this honorable court. Your lordship, first minute comes to page 37. Page 37. The earlier order passed by Justice Manta, on the basis of which the proceedings have been done under the Highways Act. The simply direction, the concerned officer, page 38. Concerned officer shall embark upon an inquiry, and after hearing the writ petitioners and private respondents, either in person or through legal representatives, and pass a reasoned order. That's the operative part. Lord, kindly bear in mind, in this writ petition, the petitioner before your lordship were not made a parties. Not made parties, they were not parties in the petitions. Lord. Now, Lord, kindly comes to the title deed, which is at Lord, page 22 to 27. Lord, page 22, just for once, Lord, your lordship will find Hapija Vedam, Rupa Khatun. Hapija Vedam, number 1, owner, Habiba Khatun and Rupa Khatun's petitioners before your lordship.
Were given an opportunity of hearing by the
No,
authority?
no, not at all. No notice opposed served upon this. Let me complete. Let me just apprise your lordship the facts.
No,
That
because you are challenging the 10-1 notice in the
notice and the demolition order itself. Last demolition. Kindly permit me to place my case. That this is not the last demolition order. Last demolition order which has been passed. Earlier demolition order they have not been acted upon. Just yesterday, we got this order. They are to demolish on 5th of October 2010.
Please show me the notice.
Prior to them, kindly take this notice.
You're challenging the
That one, that they did not act upon that. Subsequently, in continuation of that original order of the appellate authority, they passed the fresh demolition order because of the election. Probably they could not, police forces were not there. This is the demolition order, which is to be demolished on 5th of October. Your lordship will not find my names, the names of the petitioner, if your lordship. Now,
so this is a 10-3 order.
yes, 10-3 order. Now, but before going to that,
which is appealable.
Yes.
How
Now,
will this
I have filed the appeal. I have filed the appeal. The original order, pursuant to the demolition order is being passed. Let me come to the first minute. I am the owner of plot number, kindly bear with me, plot number 1203.
If I do not want to go into the merits at all.
No, merits not here. Merits have been decided.
Pending?
No, he has decided. Even DM decided. DM decided.
He is
beyond DM's order. Your lordship will find the appellate orders. Your lordship
has already dealt with the entire matter. And
lordship. No, my understanding not trying. In my matter.
Yes, same matter, my lord.
The same matter. Let me place my case. The petitioner before lordship may be unauthorized document, may be very bad person, but they are entitled to get in notice. No notice was served upon my husband. Notice was served upon my husband.
Same.
Who is not the owner?
Order,
lordship kindly comes to the your lordship has gone to the deed. Records of rights are also there. Only one thing. My plot is 1203. 1203, and there is a license of shop running a shop which is at page 35 and page 36.
That is immediate.
No, 1203. Now they want to demolish my shop on that plot, and your lordship will find the plot number different from the appellate authority's order and the magistrate's order. Lordship kindly comes to.
Why are you worried?
They are going to demolish the entire structure over there. And when lordship they are confused about the plot numbers. Lordship kindly comes to the appellate orders or appellate authority's order, page 75. Just for once, page 75. In the third paragraph, from the second paragraph, last 4 lines. And the demarcation report has been relied upon, which has not served upon me. Violation of natural justice. Lordship kindly comes to page 75. Just for once, page 75, third paragraph, last 4 lines.
Yes.
It is clear. from the demarcation report that,
75.
yes, my lord, page 75, my lord, appellate authority's order, DM's order. Just after 74, after 70, kindly permit me, can we please don't,
Complete, please. He's facing an order of demolition.
kindly permit me, Lord.
Yes.
Lord, page 75, Lord.
Yes.
Lord, third paragraph, last 4 lines, 5 lines from the, Lord. It is clear, Lord. Has his lordship got it? It is clear. It is clear from the demarcation report that the present appellants made an unauthorized construction over the culvert, which is situated in plot number 1202 under Muja such and such. Now, I have got the sanction plan of the culvert. Now, here the appellate authority refers to plot number 1202 and the original reasoned order, which mentions 2 other plots, which is not the appellate authority's order. Kindly comes to the reasoned order at page 45. Rather, not page 46.
You were the appellant before the district magistrate.
No,
My lord, he was.
I was not a made a party.
My lord,
I was not given a notice.
My lord.
I was not heard.
Kindly see the.
But kindly see page
Who are the,
46.
who are the respondents? Kindly see the who are the respondents?
Abdul Rajak Mullah.
No,
No.
no, I am not Abdul
Yes,
Rajak
that-
Mullah. Kindly
yes.
see the petitioners. Hafija Khatun. Page Hapuja. I am not Abdul. Petitioners before lordship. They are distinct. Their wife has been the owner.
Daughters.
The wife and daughter, so they are entitled to get the notice.
Sir, please have some patience.
If my husband is given notice, that does not serve the purpose. The absolute owner of the allegation made against whom I have the licensed owner. My husband doesn't reside with me even. So I have not given the notice. My husband took steps on his own. The land was gifted in page 2012. Page 22. BLRO should have not made this inquiry. Who is the landowner? Now, your lordship, I was just pointing out that in page 46 in the reasoned order, the lower authorities order, the 2 plots are mentioned 1202 and 12021. But in the appellate order 1202, my only submission on the garb of this demolition notice, the shop which is being run on 1203, for which license is given, that should not be demolished. Other parts let be demolished. I do not mind.
03 is not the concern of the.
Yes.
But they are, but that is the shop owner. Then the appellate authority says whatever. They are confused about the plot number. One to kindly lordship may.
Confusion.
Let them. Yes, there are 2 plot numbers they are mentioned. Kindly page 46. They are mentioning 2 plot numbers in the as per demarcation report 1201, 1202. And page 75, I have pointed out, the appellate authority says plot number 1202.
Yes.
Now, their demolition should be restricted to on that only, not my plot. On 1203. That is not shop license, which is for which is given, and I've got the license of the sanction plan of the culvert or 1203. And demolition demarcation report, which is not they are denying, that was also not served upon me. So let them not hear all the parties afresh decide on which plot these shops are there.
30th May notice was not implemented, you say.
No, that is also admitted fact.
Yes.
Subsequently, because of the Panchayat election, probably they said that was not able to
Your
subsequently this
lordship's-
demolition,
Lord-
latest demolition order
Your
is.
lordship's own order kindly sees. Lordship has.
Referred to an order dated 7th December 2022. What is that order?
That is the writ petitions order, 7 December. The 7 December order is the
Page 51.
page 51, that is the original proceedings before the executive magistrate. All these hearing proceedings were
Page 51,
taken
second paragraph. Last
without
paragraph.
giving any notice upon me. All the interested private respondents parties should have been served notice as per direction of this honorable court. This is the original executive magistrate's order, relying on the report, and the relevant page is page 52. Page 52, Madam. One of the alleged encroachment submits that the sanction of the culvert has been accorded by the PW authority, had constructed a toilet over the wings of the said culvert for public use, and he submits that is normal flow of such and such. So here these no plot numbers are there, but in the next page, page 53, plot numbers are 1201 and 1202. And in the appellate authorities order, same demarcation report relied upon, there refers to plot number 1202. let there be fresh demarcation by the BSRO after giving me opportunity of hearing.
no.
Because my land should be protected. My shop should be protected, for which I've got the license. 1203. Even though, my lord, whoever the allegation made against whoever the persons, they should be given notice and opportunity of hearing. Let them be clear on which plot, 1201, 1202, 1203. In one part, they mention 2 plots, and another part they mention 1.
Demolition notice. You
But
could read
the-
that by way of a supplementary affidavit.
Yes, my lord. The demolition notice is page 78.
Page 78.
Page 78, which is not been
Given portion is-
implemented. Page 78, which is not been implemented.
Due to
They are also, my
election.
lord, they are also does not mention any plot number. Page 78. In terms of the earlier order, they refer.
Your repetition is on the basis of documents which are not implemented.
Documents,
Documents which are.
right, Mother, they have just served during the pendency, right? Yesterday, I have got the copy. This is the order, a demolition that I have handed up, which is to be acted upon on 5th of October.
Now, my lord, kindly allow me to submit, madam.
And in this demolition notice earlier also, your worship will not find any plot number.
Yes, I shall make it clear, my lord, entire thing.
So they should make,
lord,
point out the plot numbers. I
Kindly
don't
s-
mind.
Kindly see, my lord, the deed which he has annexed, page 22. My lord, the deed dated 9th November 2012. My lord, the Hafiza Bibi, the petitioner herein, my lord.
Yes.
My lord, these deed was, my lord, made by whom?
Husband.
Abdul Razak.
Yes.
My lord, long back, my lord, all along Abdul Razak contested the game. Before the SDO, before the district magistrate, appeal was also filed by the Abdul Razak. And with Abdul Razak, one Asim Haldar was also there. Lordship, last occasion, Lordship, I have handed over the copy of the order passed by my lord. The Asim Haldar approached before this.
I'm not
Honorable
aware
court.
of that anything, Lord.
Wait.
Hmm.
Against the order passed by the district magistrate, where same thing was mentioned by my dad, that due to panchayat election,
But he was given a notice, he was a party. He was a party.
Due to my lord, last page of your lordship's order, which I have annexed.
Yes.
My lord, that was, my lord, there was direction for demolition of the order in comply the order of the district magistrate. 10-3, 10-4, entire thing was completed. Now during the execution, my lord, they due to non-ability of the police, but that steps were not taken up. Then lordship will kindly take that Abdul Razak contested the game. He has never stated that I have already handed over the transfer the land to my wife and to the daughter. Nothing was now after the final conclusion, when the entire thing, my lord, was concluded. Now demolition work is going to be held. Then, my lord, they have come with the plea that wife and daughter, they are coming picture that we are not given any opportunity. From the beginning of 2000, Justice Mantha, your lordships, everything was dealt with. Kindly see the page. Lordship will get the order of the appellate authority. I am placing order 23rd March 2023, page 74. When page 74. Top of the page, Lordship will get Abdul Razak Mullah. His appeal was taken into consideration.
Yes.
And my lord, that was dismissed. And then my lord, SDO, before the SDO 10-3 or 30, lordship, that order was lordship I am placing. Kindly take up page 53, 54, 53. These are the page. Here lordship will get the Abdul Razak was there. And the funny thing is that, my lord, till that day, they were mum. They did not disclose that I have already handed over the land, transferred the land in favor of my wife and the daughter. 2012 deed never. The wife and daughter, they can also contest the game by filing an application for addition of party. That was not done. Inquiry was conducted. There they did not approach. These are my land.
Why you are holding inquiry over my land?
And another thing is 1203, plot number 1203
We
has
are-
been,
We are not interested. We are interested in respect of 1202.
Let it be recorded. Let it be recorded.
the deed is in respect of 1203.
Three.
Transfer.
Three.
Let
And
it be
And the
recorded.
petitioner's claim is also on 1203.
Yes.
Whereas the notice, the DM's order pertains to
1202.
1202.
And my lord's final order was passed on that last occasion over the 1202. And is the,
My lord, Oshim Haldar was a party. Let it be recorded that in the demolition order, in the demolition order, there is no plot number. Let it be recorded in the demolition order. Final order, 1202. I'm not minded with that. Because in the demolition order, there is no mention of plot number. Abruptly, they will demolish and my shop.
Not necessary. Let the demolition be done in terms of the 10-4 order.
10-4 order, no pension, no, the plot number is
It's
required.
recorded.
So two plot numbers, but in the appellate authority, one plot number,
my lord,
1202.
kindly allow me to hand over this. my lord.
That 12, আরে যা দিয়ে ফের আমাকে copy দিন, I am entitled to get the
ওটা
copy.
order মধ্যে উঠে গেছে। বইয়ের মধ্যে অসীম
No,
হালদার,
I am not given, Oshim Haldar was made a party there. He was a party, he was made, I was not made a
আব্দুল
party.
রাজাক is C and D.
Whatever it might be, Abdul Razak, I am not appearing on behalf of Abdul Razak. I was not made a
And
party
Asim
there.
Haldar is, my lord,
You also do know, but you did not make me party intentionally.
everything, my lord.
And in clubs with Rajak Mullah.
My lord,
Lord, let it be, Lord, in the plot number mentioned in the demolition notice, no plot number mentioned in the demolition notice, because there are two plot numbers mentioned.
1203 will not be touched.
Yes, yes, that will be that.
I am not on the over that.
Yes,
I'm
yes.
only the
I
order.
got an order.
Yes,
I
yes.
dispose of the petition recording that 1202 you can demolish.
Yes. My lord.
1203.
Yes,
My lord,
there are C and D.
My lord, kindly.
80 square feet and 40 square
No,
feet.
no, that
Pub
will be
and
taken
toilet.
care of. That will be taken care of by the authorities.
Heard learned counsels for the parties. The
Yeah.
petitioners
City.
challenge
My lord, our claim is about 1202,
two. Yes, yes.
not 1203.
I'm dictating the.
ঠিক আছে,
ordinances.
ঠিক আছে।
The petitioners have primarily challenged an implementation notice dated 30th May 2023, which has admittedly not been implemented till date. Paragraph. Learned counsel for the petitioners
Then may I take your lordship's leave, my lord?
claim title in respect of plot number 1203.
03 কেন? Government land is 1202.
I have heard, sir. Let me dictate. You're repeating. One, 203. কি বলুন, the petitioner's claim, তাই তো? Counsel, the petitioner's claim title. The petitioner's claim title in respect of plot number 1203 in Mouja Purbo Durgapur, comma, jail number 111, comma, police station Polta, comma, district South 24 Parganas. Stop. The it is submitted on behalf of the respondents that pursuant to an order passed by a coordinate bench of this court on 6th July 2021 in WPA 10787 of 2021, comma. Notice under section 10(1) of the West Bengal Highways Act was served upon all the alleged encroachers of plot numbers 1201 and 1202, pursuant to which an order was passed. An order was passed by the executive magistrate, comma, Diamond Harbour, comma, South 24 Parganas on 7th December 2022 under section 10(3) of the Act of 1964. Directing all the encroachers to vacate the said plots and deliver possession of the same in favor of the assistant engineer, comma, PWD, comma, Diamond Harbour subdivision within 10 days from the date of receipt of the order. The husband of petitioner, the husband of the first petitioner appeared before the authority in the said proceeding. Stop. The husband of the first petitioner, the name বলিন Abdul Razzaq Molla. Stop.
And the father
The
of the
order was carried in appeal by the same person, Abdul Razzaq Molla, under section 10(4) of the Act of 1964, and by an order passed on 23rd March 2023, comma, the district magistrate, comma, South 24 Parganas disposed of the appeal disposed না করে dismiss the appeal করুন, dismiss the appeal and affirmed the order passed under section 10(3) of the Act. Since the order could not be implemented earlier due to the panchayat elections, comma, a fresh notice has been issued on 19th September 2023 by the assistant engineer, comma, PWD, comma, Diamond Harbour subdivision to the subdivisional police officer, comma, Diamond Harbour, comma, South 24 Parganas for implementation of the order passed under section 10(3) of the Act. Paragraph. It is categorically submitted on behalf of the petitioners that the petitioners have no claim in respect of plot numbers 1201 and 1202 upon which encroachment is alleged. Stop. The petitioners only claim title in respect of plot number 1203, which is not the subject matter of the proceeding under section 10 of the Act.
Grateful.
Paragraph. In view of the above, comma, this court is inclined to hold that the concerned authority, comma, being respondent number 6.
Yes.
Six. Be directed to implement the order under section 10(3) of the Act in accordance with law. Paragraph. The writ petition is accordingly disposed of, directing the 6th respondent to implement the order passed by the Executive Magistrate, comma, Diamond Harbour on 7th December 2022 under section 10(3) of the Act of 1964. And take necessary steps for removal of all unauthorized encroachments unauthorized কথাটা কেটে দিন, encroachment সবসময় unauthorized. Removal of all encroachments from plot numbers 1201 and 1202 within 1 month.
Within 1 month. Last order was also there.
Within 1 month from the date of communication of this order. Stop. Paragraph.
My last order was within 1 month from this day. And this is my no.
Yes.
No. Josh Saheber আগের order.
Let it be from date of communication. The 8th paragraph, the 8th respondent is directed to render all necessary assistance to the 6th respondent in implementation of the order. Paragraph. It is made clear that
8, not 8, that is কোনটা? হ্যাঁ ঠিক আছে, ঠিক আছে.
8, there is no other police authority.
Grateful, Lordship. 8.
Paragraph. It is made clear that no step shall be taken by the authority in respect of plot number 1203 which, comma, according to the petitioners, comma, is owned by them. Disposed of which of you? Huh? No. Motion stage.
ঠিক আছে, পুলিশের উপর ডিরেকশন আগে একটা পুলিশের উপর ডিরেকশন দেয়
Mention.
Mention matters item number 305.
For 305, I am for the petitioner, my lord.
Give me a minute.
One of the matter relates to more seeking issuance of land user certificate, and on the same RX. On the same RX, my lord, you will also pass an order, my lord, on 31st January 2023, my lord.
Same RA case, my lord. Your lordship directed in the order to make a comprehensive representation, and that should be considered. Your lordship's order is there.
রেকর্ড তো করবে এ ডিরেক্টর অফ এমপ্লয়মেন্ট না সেটা তো বুঝলাম কিন্তু সেটা ডিরেক্টর অফ এমপ্লয়মেন্ট পার্টি করেছি কি হলো আগে কি হলো সোয়াপ করেছেন না বলবে কি ছিল কেসটা কি
You have already submitted a representation. Where is it? Page?
But no, I have not made any specific representation. That's why your lordship on the earlier occasion also directed me to make a comprehensive application.
File a representation. Yes.
সিমিলার
In the next page, model, your lordship directed.
You are the daughter.
Daughter
The
of the land loser. Nitai Das is the land loser, my lord. But page 24 is the my lord.
You are the land loser. You're not the daughter.
No.
Nitai Kumar Das is the petitioner.
Land.
It is contended on behalf of the petitioner that the land of the petitioner was acquired by the respondents with a RA case number 103/09-10 within bracket NH-34 bracket closed, and compensation was paid to the petitioner for the same. Stop. The petitioner seeks to submit a representation before the concerned authority for enlisting the name of his daughter in the exempted category as a member of the family of the land loser. Land loser in terms of the notification issued by the Labour Department, Government of West Bengal
Page 25.
on August 21, 2002. Stop. The petitioner seeks compassionate consideration of the representation. Paragraph, learned counsel for the respondents submits. Special land acquisition officer
Yes, my lord.
special land will issue the certificate
3, my lord.
or director of employment who will
director of employment will register the name of the candidates as exempted category
So it should be
unless the certificate I hope my lord, it will be better to the director of employment
Well, unless I get the land loser certificate, the employment exchange officer cannot register my name. So our first land loser certificate to be issued by the special land acquisition officer. Then I shall register my name in the National Employment Exchange. That's why your lordship earlier occasion directed the special land acquisition officer to consider his case and pass it in order.
let him consider. The third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the requisition is disposed of with liberty to the petitioner to submit a comprehensive representation before the third respondent within 7 days.
10 days, my lord.
10 days, within 10 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 1 month.
I don't know whether Puja is coming 2 months instead.
Within 2 months from the date of receipt thereof, upon affording reasonable opportunity to all concerned, including the petitioner, comma, in terms of the notification issued by the Labour Department, Government of West Bengal on 21st August 2002, August 21, 2002, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Develop leisures. That's
2002. 21st August 2002. Next.
Number 306.
Yes, my lord, this is my application. Every service. My lord, the very short point involved in this petition.
Respondents? Who is appearing for the respondents?
My lord, I have filed the very service.
Only state?
Only state is the respondent.
Mr. Dev, may I request? Please serve a copy to Mr. Dev.
Presently, I have got only one copy. In
course of the day.
Then, my lord, kindly take it up on Monday.
Can we take it up today itself?
Yes,
What
it's
is
a very
the
short,
matter about?
very short point. Very short point involved in this petition. The petitioner before your lordship, on the strength of a deed of transfer, submitted an application for mutation before the authority concerned, the respondent number 2, for mutating his name in respect of a plot of land lying and situated at Kolani. My lord, the said representation or application for mutation was not considered in time. The first round of litigation before this honorable court, when his lordship, Honorable Justice Soumitra Pal, when his lordship then was pleased to direct them to consider the representation by passing a rescind order. Lordship will straightway come, page 58.
It has been subsequently turned down.
No, it has not yet been turned down, but what happened? Well, thereafter, the rescind order they have passed. They said in the rescind order, if you'll also kindly take page 59. 59.
Yes.
Has you also got it?
Yes.
But the last but one paragraph, as of now, the government has published a notification for allowing transfer of plot of Kolani Roundship leased out by the Urban Development Department on realization of transfer permission fees by number such and such dated 1/10/12 with reference to the previous notification dated such and such dated 12/7/2005. Therefore, the petitioner may proceed under the notification to the competent authority to solve the issue of mutation of the instant case. Here is my case. So this notification they have stated.
You are the transferee.
I am the transferee. This notification they have stated. The notification came into force in the year on the 12th of July 2005. So therefore, prior to that notification, if the deed is executed, then this notification shall not apply. My lord, on that ground, again another writ petition was preferred before this honorable court, when the same was disposed of by an order dated 18th November 18 by the coordinate bench, Honorable Justice Amrita Sinha.
I think Mr. Day will need to take instructions on this. It's not a simpliciter disposal. Because reasoned orders have already been passed. So let Mr. Day come back with instructions.
Then kindly fix the date on the as a 12:30 matter. Please, Lordship, kindly consider matter because the petitioner, why I am submitting so.
30 matters only for a day, only for the first day. That's all.
Then at least top of the list because.
Let us see. Let us see. Affidavit of service, none appears for the respondents despite service. Mr. Day, who is present in court, regularized court, and copy service direction. The Learned Counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 13th October.
13th October.
14 the form of
Yes.
14 the form of
There.
13th or 14th?
13th. 14th is a holiday. Learned Counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Please
My-
serve an advance copy.
But kindly, a little bit top, my lord, if you lost me.
Let us see. Let us see. All matters cannot appear at the top. Is it?
But why I'm
That's
submitting?
the submission made. in
I ought
advance.
not to have submitted because I'm only submitting because this petitioner, he's an acute patient of cancer. He's suffering in the bed. That's why I'm submitting. The only thing is this.
Bashu, fairly at the top. Fairly at the top.
I'm grateful to you. I'm obliged.
Next.
307.
Already I have served.
I am appearing on the state.
I am for the private respondent number 9 and 10.
The West Bengal Highway Act 1964 regarding removal of unauthorized encroachment from the land of the Public Works Department, my lord. I have made an application, page 14, my lord, before the authorities. That application should be considered in accordance with law within a certain period.
Yes.
What happened, my lord? The petitioner interest of the respondent number 10 executed a deed of gift in favor of her regarding 2.5 decimal of land. Thereafter, land was converted under 4C of the West Bengal Land
0.5
Contract.
decimals in plot number.
Plot number 215. 215. 215. Thereafter, my lord, plan was sanctioned by the competent authority and I constructed the building and I am residing there. My lord, I have specifically stated that I have not encroached the land in questions. Thereafter, my lord,
The encroachment is alleged in 253, not in 215. 215 may be your land.
215 and 217.
Yes, maybe.
Two plot.
The alleged encroachment is on 253.
But in the prayer portion, lordship, kindly come to prayer portion of the writ petition.
In front of the petitioner's Rayati land, 215 and 217.
In front of petitioner, right, 215. Respondent number 10 is concerned with 215. And respondent number 9 is 217.
These lands are actually not the subject matter of the writ petition at all. The subject matter is the encroachment in front of these lands.
Right, in respect of that plot. And my
The
lord,
encroachment is on 253.
253.
my
Yes, I
lord,
got
lordship,
it.
kindly come to page 13. There is a record of rights. In 217, there is a Borga recording.
Whatever may be, but my question
215.
allegation against 253.
In respect of 215, there is a Borga recording.
I repeat, 215 is not the subject matter where encroachment.
Very
has
good,
to be
my
done.
lord.
It is 235, 253.
50, my lord, let the BLRO take the measurement,
Let the
submit a report.
representation be considered. I will not make any observation on merit.
Yes, my lord.
Yes, you will be given an opportunity of hearing before the authority.
But first measurement to be taken by the
Yes,
BLRO.
that has to be done in order
My
to
lord.
ascertain encroachment.
My lord.
My lord, they have already sent the PLR to
Pursuant to the representation,
আমাদেরকে report
it has proceeded.
Respondent number 4, my lord. Direction upon the respondent number. Report.
Ward number 2.
Plot number 253. 253. Public Works Department land.
আমাদেরকে
Affidavit of service. The petitioner claims to be the recorded owner of the plots in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD land adjoining his plots, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority in this regard on 29th May 2023, which is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the private respondents have acquired title in respect of a portion of plot numbers 215 and 217.
So far the respondent number 10 is concerned.
It's submitted on behalf of the private respondents that the 10th respondent has acquired title. The 10th respondent.
She is the owner of the land in questions. In respect of 2.5 decimal of land.
I have stated a portion of them and have not encroached upon any portion of the PWD land.
Right.
Paragraph. It is submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, the Block Land and Land Reforms Officer, Potashpur Block -Roman 1, Post Amarshi, AMARSHI, District Purba Medinipur, has been directed by the Assistant Engineer, Tomluk Highway Subdivision, PW within bracket roads, bracket closed directorate, by a letter issued on 19th June 2023 to demarcate the land in front of Rayati plot numbers 215 and 217. Demarcation has not been done as yet. Stop. The demarcation is yet to be held. Paragraph. In view of the above, this court is inclined to hold that since the Block Land and Land Reforms Officer has been directed to demarcate the plot in dispute,
And also take measurement, my lord.
alleged demarcate includes measurement, allegedly encroached upon by the private respondents,
With giving an opportunity of hearing.
such process of demarcation be conducted at the earliest and demarcation report be submitted before the assistant engineer within 1 month.
Yes.
Demarcation report within 1 month.
1 month.
Within 1 month from the date of communication of this order. Stop. Upon receipt of the demarcation report, in the event it is found that the PWD land or any portion thereof has been encroached upon, proceeding under section 10, it's PWD land.
Yes. Under section 10.
PWD land.
PWD.
Proceeding under section 10 of the West Bengal Highways Act 1964. In the event, and in the event, the assistant engineer, being the fourth respondent herein, is directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months from the date of receipt of the demarcation report. Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents.
9 and 10.
Yes.
9 and 10.
Yes. In accordance with law.
And at the time of demarcation, my lord, PLRO is directed to sub notice upon the private.
Yes,
respondent.
formality to
him. Grateful to you.
Next. Yes, number 2. 13652 হবে। কেউ আছে ডিপিডি নাম্বার 308 anyone?
308, I am for the petitioner. But it is wrongly appearing.
Yes, so let's.
Yes. Yesterday it was 323, I am told that this is the matter. This is my affidavit of service.
Correct file টা এসছে?
Well, 14 Shatak of petitioner's land.
Server taken up. It will be difficult to upload the order in the server.
May I come back on Monday?
Wrong number. Yes, I'll just make it not today.
Fine. Affidavit of service. Somebody. Grateful.
At number 21.
Mr. Jishan Iqbal Hussain appearing for the petitioner is suffering from high fever, Lordship.
You come back after vacation.
Lordship, praying for not today.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 30th November. 30th November. Next.
Number 22.
My lord, I am for the petition in this matter.
Is engaging for number.
I cannot hear you, sir. I'm sorry. Yes.
I'm paying for not today, my lord.
Consider for yes.
Why not today?
My lord,
I'm on behalf of the private respondent, your lordship, I'm being led by Mr. Rabar. He is appearing in a coordinate petition. A short passover or not
The
today.
submission.
my lord, may I please?
বলুন না।
You are appearing for the state.
Yes.
My lord, there is only one difficulty because my lord, I have prayed for an interim order. The difficulty is that my lord, my land and there is ingress egress through the PWD road. Now, my lord, this PWD road, there is a vacant land between my land and the PWD road. Now, the private respondents are constructing shop room on that land between the PWD and my land. So, my ingress and egress are hampered. That is a difficulty, my lord. And section 910, if your lordship kindly sees of the Bengal Highways Act, there is specific provision under it. So, my lord, this is the difficulty interim protection, my lord, it is required. In the meantime, my lord, I have made a representation that may be considered and the consequential steps may be taken by the PWD. Till then, my lord, it has.
Be done.
Lordship?
I'm asking the respondents.
Lordship, a short accommodation, your lordship.
That is
He is arguing before court, coordinate court, your lordship, a short.
But make so much of a submission. Why are you not ready with the brief? Very unfortunate. Very unfortunate.
So that is the
Next
difficulty.
week, come back
Otherwise,
next
next matter kindly fixes.
Obliged.
I will.
Actor kindly fixes it.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 27.
27th. Grateful to you, Lord.
Grateful.
Or under the same heading. Under the same heading.
Same heading.
Yes, yes. But can there be any precedence, my lord? Can it
Yes.
be? Can be any precedence?
Same heading.
No precedence. Because the interim order I am praying for because they are doing it in war footing basis,
Come back.
constructing, my lord. That is the difficulty. Grateful to you, Lord.
Number 23. Twenty-three.
I'm praying for not today, Lordship. We have a state respondent.
Here for the,
State.
who is appearing for the petitioner?
23.
No one. I was watching Mr. Chatterjee, waiting for not 2 days and adjournments. No one for the petitioner. So this will be a dismissal, not today. Dismiss or defer. None appears for the petitioner.
Dismiss with you.
Number 24.
May it please your lordship, I beg to appear, my lord, on behalf of the petitioner.
Yes.
My lord, the petitioner before lordship is a central government undertaking. Petitioner before lordship is a central government undertaking. and the respondent is also a central government undertaking. Between two limbs of the central government, there is a dispute, a controversy. I mean, they beg to have it resolved by your lordship. Now, the controversy is my client, a central government undertaking, was favored with a grant of running 5 way bridges in Calcutta port. 5 way bridges in Calcutta port within the customs area, private. My lord, that was on the basis of a policy and on the basis of an application my client made before the authorities. The application was for a grant of 5 way bridges for 30 years. This is on record. My lord, they granted a 5 way bridges for 10 years only, saying that for further period, we are required to take the approved. Sorry. Lord, can your lordship hear me, Lord?
But I am opposing, I am taking the point of maintainability. So there's a writ petition filed in June. Matter appeared twice before the regular court. Lordship kindly takes a look at if the order files there. Lordship 13th September. First it appeared on July 7th. If there was such urgency, Lordship.
My lord, I have not yet.
July 7, 2023.
That makes it.
On the maintainability issue.
Yes. I will make submission on the maintainability. Well, here I have got a twofold maintainability. Twofold maintainability point, because this is an urgent determination of Justice Shubhakaji Bhattacharya, which your lordship has till today. Now, urgent though.
Is it a fact?
It doesn't say urgent. Look,
Extremely, I have not been able to make my sufficient.
Oh, but I'm so sorry. It is landed matter.
Mr. Mukherjee, since the maintainability issue has to be taken up first.
Let him place the maintainability point, my lord. I beg to make it.
Well, I got confused because this they have challenged a tender for allotment of weighbridge. I thought this would be
I was confused.
I'm very sorry. Well, I was under the impression that because this is now, lordship, what it appears is, lordship kindly takes a look. Why I'm saying it's not maintainable is, firstly, this is totally beyond the scope of the writ petition. The writ petition, what reliefs are, lordship kindly takes a look, is for specific performance of an agreement. Specific performance of an offer letter, lordship kindly see the writ petition, page 34. A writ of or in the nature of mandamus to issue command on 4 and 6 to register lease for 30 years for 5 way bridges at Kolkata from the date of the letter of offer of 20th November after collection for 30 years.
Yes.
The letter of offer 20th November 2023 is at page 110.
2013.
2013 is 110. The first, this has reference to your letter number so-and-so dated so-and-so requesting for allotment of land for installation of way bridges. It has been decided by the appropriate authority that long-term lease 10 years without any option of renewal may be granted in your favor. In your favor, in respect of 5 sites at Kolkata dock so-and-so. Standard lease from. Now, lordship kindly comes to clause 1.
Sorry to interrupt, my lord. Mr. Mukherjee is there. So
I am there.
My lord, may we please the
I'm taking the maintainability of this. No.
Has to be taken up first.
Yes, well, because whether
But
this
he is going into the
no, because I am showing that this application is not maintainable. This is a writ petition. This is for
Based on this, they've asked for 30-year renewal of lease.
That is on merits.
Well, whether this application is within the scope of the writ petition. Well, I am on that. Your Lordship kindly takes a look at the prayers in the application. Application prayers, page 11. Challenging a tender that was published, my lord, 4th of September 2023. 4th September 2023.
So let us deal with the writ petition as a whole. You can make your submission on maintainability at that
Well,
time.
so where writ petition is concerned, Lordship, as I said, on 1st July, they took adjournment. Thereafter, once again on 13th September, on the prayer of the petitioner, matter is adjourned, and we take the point of maintainability 13th September. When a writ petition is filed in the month of June 2023, they cannot ask for an interim order in the month of September.
Not yet.
That makes the writ petition
I shall
not
be
maintainable.
submitting that.
They have not yet asked for an interim order. Yes, Mr. Mukherjee, please.
My lord, I was making my submission. It is a matter between two central government undertakings. My client is a central government. I'm not audible, my lord.
Very clearly audible. I'm sorry, Mr. Mukherjee.
My lord. Just a second, my lord. Okay. Sorry for that. Am I audible, my lord?
It's better now. Yes.
Yes. My lord, this is a matter between two central government undertakings. My client, my lord, in response to a policy of the port commissioners, filed an application for allotment of 5 sites for running weighbridge within the customs area. That application was made for 30 years. They, my lord, initially granted me for 10 years, saying that further 20 years will be granted subject to approval of the central government. Initially granted for 10 years, and then my lord said, in the same letter, further 20 years will be granted subject to approval of the central government. My lord, in the Act, Section 34, there is a provision for grants up to 30 years, no central government approval is necessary. Secondly, kindly turn to my lord, Section 34. Section 34.
Yes. Might be a little marked, kindly doesn't take us.
Yes.
Section 34, my lord. The second proviso. Provided further that no contract for the acquisition or sale or immovable property or the lease of any such property for a term exceeding 30 years, and no other contract whereof the value of the amount exceeds such value or amounts as the central government made from time to time fixed in this way shall be made unless it has been previously approved by the central government. Therefore, 30 years. I apply, Lord, not for exceeding 30 years, but for 30 years. No central government approval is necessary.
Yes.
After granting me for 10 years, they send the matter to the central government. And the central government said, no such approval is necessary. Then, my lord, I applied the kindly grant me for 30 years. Formerly, you have not. The matter was again sent to the central government, and the central government at page 1, I'm making it very short. At page 139, kindly turn to page 139.
Yes. 131.
The dispute is with regard to Calcutta and Haldia. I'm not addressing your lordship with regard to Haldia. I'm confining myself to Kolkata. Kindly look at, my lord, this communication. This is dated, my lord, 21st October 2020.
23rd October.
This is from the Ministry of Shipping, the ministry concerned. Award of contract for installation of 30 way with 30 Kolkata Post Trust. The undersigned is directed to refer to the above mentioned subject and to say the following. In consideration of the persistent and high demand for waivers at Kolkata docks in Kolkata Port Trust, a lease of 30 years in respect of 5 sites at KDS for installation and operation of which was granted. Initially for 10 years, matter was referred to central government. No approval was necessary. In any event, the central government is saying was granted. My lord, my 10 years is going to expire in the month of November. They have invited a tender. I have filed a my lord, annexing the tender to grant fresh tender for these 5 sites. Central government is saying it was granted for 30 years. My 10 years is expires in month of November. In disregard of it, in disregard of the central government decision, they are going to, they have invited tender and going to make a fresh grant. My first point will be before your chief that they cannot grant it because the central government has said it was granted. Kindly look at the language. 5 sites in KDS for installation and operation of waivers was granted to HSCL. That's my client. Can they issue a tender, my lord, in regard of this government decision? And there's no ambiguity about it. And this is the concerned ministry, Ministry of Shipping. They, in disregard of it, they are issuing, my lord, they have invited tender, and when I complain, they say the contract was concluded. Nothing doing now. Kindly turn to that, my lord.
Page 143. Page 143.
Page 143.
Yes.
Highly stand from Lord, paragraph 2II. In response to my representation, they say concluded. And I'll take your lordship to that interim management. They give me 10 years for the time being, which page? But 10 years for the time being.
110. Page 110.
They say it's concluded. What kind of concluded contract? Kindly, my lord, have a look at.
Page 110.
One 110. This is the only ground. Kindly.
Where is the offer letter?
The offer.
110.
110.
Second paragraph.
Grant of lease of 10 years without any option for renewal in respect of 5 sites. Kindly turn, my lord.
So this is without option for renewal.
No, there is.
No. There is no. This is. I am concerned with chapter 1I, second paragraph. They are granting for 10 years then. And so far as the bank pay for 30 years, they are sending to central government. I second paragraph. This is their say concluded contract. And the central government is saying they have granted 30 years.
This says it was being examined, not granted.
Central government thereafter saying granted. This is in 2014.
Where is that document?
2013 and then 139.
139.
139.
2020.
Subsequently,
110 is 2013 and 139.
this is long thereafter. And my lord, my prayer was for 30 years. Kindly have a look at my prayer. For the time being, they granted for 10 years. For the balance, for the rest of the period, they send it for government of India's approval. And the government says no approval necessary. It is granted to you. 139, kindly refresh your memory, my lord. Central government was granted to me.
Yes.
And first grant for 10 years was not a concluded. First grant for 10 years was not a concluded contract. That was a contract, my lord, a grant for the time being at page 110.
Yes.
This is an arrangement, not a contract at all. Arrangement for the 10 years for the time being. For the rest of the period, central government is approached. Central government says not necessary, and 11 it was granted to you. And in disregard of, I am very shortening it, my lord. In disregard of all facts, they have invited the tender and not renewing not extending my period to 30 years, as central government has already decided.
Where is the notice inviting tender?
Yes.
My lord, that is in Can 1.
Supplementary.
Yes, at page?
That is not a separate application. my lord.
Can application.
Page 50. 150.
Can 1.
I have shortened it, my lord. I have not taken your lordship to all the other annex. There is no time.
Page 40.
25th September is the date of opening.
Yes, on Monday. These are undisputed facts. And only ground is earlier arrangement was a concluded arrangement. I can't alter it. I beg to satisfy your lordship that arrangement was not.
Let us
That-
continue. I think the matter needs to be heard on affidavits. That is what I feel.
My lord, kindly protect me. I am a central government
Let the process
undertaking.
be stalled.
Well, I shall make my submission. May I make my submission, madam? May I make my submission?
Will you come back on Monday in that case?
Monday, because firstly, lordship has seen, this is 25th September, the submission of the bid. 25th September, lordship kindly sees
The opening
page
of tender.
15. Opening of, if at all rights are created, it will be after 3 o'clock on Monday. Lordship, may it be first matter on Monday morning, I'll make my submission. Because Monday after 3 o'clock will be the opening of the techno-commercial bid.
Because the writ petition becomes infructuous. If this is
So, but lordship, what I was submitting is lordship takes up on Monday
at
morning.
least, let there be an observation that any steps taken will abide by the decision of the writ
My
petition.
lord, third party interest will intervene. My
Well,
lord.
Lordship can take it up on Monday morning, lordship can take it up because যদি না হয় তো মেনশন করবে এসে কোর্টে how can you say যদি না হয় lordship takes it on Monday first thing.
the matter has already been taken up.
The problem is I am appearing for response number 8.
And lordship will also see, lordship will see
Registration done.
page 5
Not able to enter, my lord, that area, my lord.
after November.
After
Lordship sees page 15, last line. Date and time of opening of price bid to be informed separately through email. So techno-commercial bids are being opened on Monday at 3 p.m.
And they are
Lordship, Monday morning I was saying, if Lordship, and anyway, Lordship knows that if anything happens, it will be, it has to
My
be
lord,
by.
there is no allegation. There is no allegation against me except that.
For a moment, for the time being.
Lordship, that will
Come back on
well, I
affidavits.
will make my submission. Lordship, one thing is to abide by result of the writ petition. Another thing is to stall the tender. Because this is a tender worth, Lordship sees 16 crores value to me.
They have no answer, my lord, to that central government
16.7
communication. I have been given for 30 years.
Lordship kindly hears me. Lordship, all I'm saying,
That I'll do.
Lordship kindly hears me.
The tender will make the render the repetition instructions.
Lordship, all I'm submitting is, Lordship, the tender Monday morning, if this is taken up, then by that time, tender will not be proceeded with further.
Yes, but will the situation change?
Well,
Will the situation change?
Clear out
the entire matter.
no,
of
but then for resisting the ad interim order, I should be heard. That's what I'm saying. After all, he's made an ad interim prayer. Could kindly hear me before Lordship, because there are many points I want to show. With it'll take me an hour's. I need 1 hour to make my submission, because this is a public tender which they want to stall. Lordship, so Lordship kindly hears me. Lordship, I'm not on.
Please come back on Monday. Mr. Mukherjee, please come back.
Monday.
You heard learned counsel for the petition.
Hello, I have shortened my arguments, my lord. Kindly don't treat me as concluded. I have shortened in, my lord.
Not at all. Paragraph, paucity of time intervenes. Paragraph, let the matter appear
Monday morning.
under the same heading for further consideration on Monday date, Diri. 25th. Fairly at the top. Fairly at the top.
More or less same position on Monday.
Top.
More or less. Sir, আজকেও top ছিল. In the motion it was top.
After all, in a court, you have to take
2 PM matters গুলো দেখে দিন।
Yes, but supplementary one.
Matter item number
I
one.
have served the copy, my lords, and the receipt copy, my learned friend is appearing, my lord, for. Oh, so which
আপনি
one?
কোনটাতে আছেন?
Number one.
ওয়ানে আছে।
MB sponge.
MB sponge.
My lord, this writ petitions, my lord, the facts, my lord, leading to filing of this writ petitions is this, my lord, that the petitioners is a manufacturing of sponge irons unit, my lord. My lord, having 200 employees, my lord, that the petitioners, my lord, it is a, my lord, 400 per ton, my lord, per day, having its capacity, my lord, that the petitioners, my lord, decided to expand the industry, my lord. So, and to also set up a captive power plant, my lord, to feed the industry, my lord. So, my lord, for that purpose, my lord, 21 acres of land is required. Petitioners was having 10 acres of land and 20 acres of land is required. Out of which, my lord, 10 acres, near about 11 acres land is situated, my lords, within the Panchayat area, Hijalgarh Panchayat area, and 1.99 acre, my lord, is situated in municipal area, my lord, Jamuria municipality. So, my lord, petitioners applied for no objection certificate for the purpose of setup of the industrial unit, my lord, and the power plant. So, my lord, I invite your lordship's attentions at page 47, my lord, that the petitioners at page 47.
Yes.
Petitioners obtained a certificate, my lord, second para. As such, the undersigned have got no objections if the land measuring 119 acres of the plot mentioned above be leased out in favor of the director MB Sponge Iron Private Limited. So no objections was granted by the municipality. Then the next page, my lord, at page 47, my lord. 48. Yeah, 48. And this is to inform you that one Pawan Kumar Agarwal, director MB Sponge and Power Limited, Shanti Niwas, Jamuria, before the undersigned to get lease for the plot of so-and-so, total acre of 8.66 acre of GHOSH land under Hijalgarh Mauja. As such, the undersigned have got no objections if the land measuring 8.60 acre on the plot mentioned above be leased out in favor of director so-and-so. So, no objections was granted by the municipality, my lord. Then, my lord, as well as Panchayat. Then I will take your lordship to, my lord, at page 53, my lord. Yeah, then, my lord, additional district magistrate, my lords, wrote a letter to the joint secretary, my lord, at page 53.
Yes.
This is a proposal for long-term settlement of government vested land in plot number so-and-so. Total area 9.79 acres in favor of the director MB Sponge and Power Limited of land. The lands in questions are vested to the state and the possessions of the land have been taken over by the government and are available for settlement. Market value of the proposed land has been assessed by BLLO Jamuria as per sale deed verifications from the local SR office, which comes to rupees so-and-so. On the basis of that market value, salami rupees so-and-so only and rent so-and-so. Prayer dated 17th May 2005 of the director MB Sponge and Power Limited project calculation sheet resolutions of Bonobhumi Samskar Sthai Somiti Jamuria, NOC of Hijalgarh Gram Panchayat, NOC of Jamuria Municipality, and vested sketchman of Khotian as enclosed for favor of your kind perusal and consideration. Then, my lord, page 54, next page. Then officer on special duty and ex-officer deputy secretary wrote a letter to the director Sponge Iron. In inviting his attention to the letter under reference on the issue mentioned above, the undersigned is directed to request him to produce NOC from Commerce and Industries Department, Government of West Bengal, as well as West Bengal Pollution Control Board for their proposal for setting up a sponge iron plant and Mauja Hijalgarh and ICRA for favor of taking necessary action. Then, my lord, the next page, page 56, my lord.
Yes.
Page 56, my lord.
Yes.
The additional secretary, Government of West Bengal, also wrote a letter to the additional secretary with reference to department so-and-so, Commerce and State. The undersigned is directed to state that NOC from Commerce and Industry Department as well as West Bengal Pollution Control Board as sought for under this department's memo number so-and-so to above have yet not been received at this end. It is therefore requested to furnish the same to this department for further action. It is for information that as per report of ADM and DLR of Bardwan, an area of 8.69 acres of land is available for settlement instead of 9.79 acres proposed earlier. It is requested to let this department know whether MB Ispat Pony Iron Limited is willing to take long-term settlement of 8.69 acres of land. The reply may please be sent within a week of receipt of this letter, my lord. Immediately, the next letter, my lord, next page, my lord, at 57. The director wrote a letter, my lord, that, my lord, with reference to your above mentioned letter, so and so, we would like to inform your good self that though we had earlier opted for long-term settlement for 9.79 acres land, we are now accepting for long-term settlement 8.69 acres of land as mentioned in your earlier letter. So, my lord, that was accepted and agreed upon, my lord. Then, my lord, in this background, my lord, then, my lord, this all happened, my lord, since it started from 2005, continued till 2012, my lord. And at this stage, my lord, there was recessions in the industries also, and duty, my lord, from 19 pandemic is there, my lord. So therefore, the petitioners, my lord, that the industry, my lord, adopted, my lord, slow down, my lord, step, my lord. So therefore, my lord, they didn't take any steps. But in 2022, my lord, then thereafter again, my lord, they initiated this proposal, and in the meantime, Lord, nothing has happened on the part of the government. And they made inquiries, and only they were giving impressions that the land record was not properly available, as a result of which lease could not be executed. So that was the impressions, and due to recessions, nothing happened. Then COVID. Then thereafter in 2022, my lord, again, my lord, that was the proposal was initiated. My lord, then I will lordship your invited your lordship's attention at page 62. Then additional secretary to the government of West Bengal, with reference to the above subject, I am directed to inform you that this department has in receipt of a prayer in favor of Messrs. Sponge Iron so and so for the purpose of expansion of its existing industry of so and so. In enclosing a copy of the applications of the company containing the land schedule pertinent to the requirement of 8.69 acres of land, I am directed to request you to do the needful and to conduct a physical inspection to ascertain the present status of the land and send a consolidated report along with the views of the proposed expansion to this department at an early date. Then, my lord, I will take your lordship to page 67.
This is again 23. This is all 23.
Yes.
20th March.
20th March. This is also inform you that MB Sponge Iron Power Limited applied for this letter is written by Block Land and Refund Officer to the Additional District Magistrate stating the status of the land. This is to inform you that the MB Sponge Iron Private Limited for long-term applied for long-term settlement on 25th July 2022 as per order of ADM and DLR of Paschim Bardhaman. Feasibility report sent to you event, but the petitioners MB Sponge and Iron Limited wanted to LTS because these lands are already under the boundary wall of the company. But as per office record, it reveals the fact that plot the land 1.19 acres of land out of 2.92 acres of land as per measurement Mauja sheet. In the above mentioned circumstances, if permissions were given for inclusions of plot number 1771, 1798 of Mauja Hijolgora and plot number 2027 of Mauja Ikra in collectors Khoitan number 1, that collectors Khotian number 1, that is Khotian number 1, the above plots may be recommended for long-term lease to MB Sponge and Power Limited. So therefore, there is everybody below the secretary, BLRO, every authorities are in favor of disposal of the land for long-term settlement, Milord. In this background, what happened, Milord? Some interested quarter, Milord, filed a writ petition, public interest litigations, Milord, before this honorable court, stating that some land grabber, Milords, grabbing the government land and they are encroaching and all this. Then, Milord, upon hearing the writ petitions, this honorable court, Milord, directed Milord to dispose of the grievance after giving an opportunity of hearing, Milord. Then, Milord, a case was initiated, Milord. Then the inquiry was initiated, and they came to the findings that the petitioners, Milord, the boundary wall, Milord, on 0.78, 2 feet, only 2 feet height of boundary wall, only 0.78 by boundary wall was there. So they have directed to demolish the work. Then I will straightway take your lordship to the order, Milord. Then the how the reason disclosed in the order, Milord, at page last.
Where is the order of the public?
Yes, Milord. Yes, Milord. At page 79, Milord. Oh, PIL order. But PIL order simply these 4 lines of order. In the second deed, he disclosed, Milord, that directing to dispose of the grievance of the petitioners. Page 61. Page 61. They gave me puri. 61. Page 61. The grievance raised in this petitions is that about 30.49 acres of government land has been grabbed by the land and local peddlers and their yes.
It's not annexed to this.
No, not it. This is the next petition by learned friend, the same identical issues he annexed, but I have not. The learned counsel for the state has pointed out that respondent number 5, additional district magistrate, district land and land reforms officer, Paschim Bardhan, is the competent authority to consider the representation. Hence, we dispose of the present petitions, permitting the petitioner to file an appropriate representation before respondent number 5, who on receipt of the same will duly consider the grievance of the petitioners and conduct an inquiry if required, and the appropriate decision in accordance with law within a period of 3 months from the date of receipt of representations and decisions will be communicated to the petitioner. Then, Milord, ultimately, Milord, the proceedings was initiated. Then day-to-day proceedings was, Milord, held. Milord, the final, Milord, at page 79, Milord. Yes, Milord. At 28th August 2023. Whereas
proceeding target.
Yes, Milord. At page 76, Milord, relevant order sheet, Milord, 16th August 2023.
73 একবার দেখিয়ে দিন, এই nature of the case টা দেখিয়ে দিন। Page 73 এর প্রথম line.
Then 73, first 73, the nature of the case, compliance proceedings at page 73. Compliance proceedings bearing case number so and so arising out of so and so. Then relevant portions, Milord, order number 3 at page 75. The hearing commenced whereby BLRO's report by memo number so and so dated 14th August 2023 has been taken on record and found that a company, namely MB Sponge and Iron, has raised constructions of boundary wall over plot number 1802 and 1806 of Mouja Hijalgora, jail number 40 also. Utso Buildcon Private Limited, my learned friend's client's second petition, has raised constructions over the plot number 2367 Mouja Hijalgora, jail 40 without having any permissions of the authority concerned, and the said lands have been recorded unto favor of the government of West Bengal under Khutian number 1, and all the constructions as reported have been erected illegally without having any sanctioned LTS, and the suit plots have remained uncultivated for a period of more than 10 to 12 years. It is also reported that some local citizens have raised their grievances against constructions over the shoot plot. So therefore, the entire plot of the land, Milord, that I have already shown before your lordship, Milord, that the BLRO, Milord, communicated, Milord, is that so far the my lord, 6.82 acres of land, my lord, the record was not available. And this fact was also known to the authorities that they raised a boundary wall because the security of the petitioners, my lord. Then, my lord,
So the
at-
plot was handed over to you. Possession was given to you.
and no, my lord, because the lease has yet not been executed. Because of that, the views were given by the BLRO that unless,
So how
because
is it
record
that
was
you
not
raised
available.
the boundary
No,
wall?
yes, my lord, because what happened, my lord, because out of the entire 8.62 acre of 69 acre of land is required, my lord. Out of which, my lord, 0.78 acre of land, my lord, that is adjacent, my lord, to my factory where the expenses is already undertaken, my lord, going on. Because 10 acres is my land and 11 acres is required. So I was given only 8.662, finally government agreed. So out of which 0.78 acres of land contiguous to my Milord area, Milord. So therefore, for the security purpose, Milord, there was really intruder and land grabber, Milord. So, and they
With my
constructed.
learned friends, just to answer this question, that this is right next to a river. Next to the river is land which is vested in the state. After that is industrial land which we have acquired. I am Milord, the Rashmi Group. But this is just one of those companies, Rashmi Metallics is setting up a cement grinding plant over 50 acres of land. And this is part of that land on which we propose to set up belongs to the government. So we have also applied for LDs. In other states, my lord, if you want to set up 10,000 people minimum employed. Other states, if you go to set up, state government comes and gives you the land. Here, my lord, this is step one, that they want to demolish a 2 feet boundary wall which has been made up so that river water does not come in. Step 2 will be pollution, step 3 will be
So
river
how is
trouble.
it that you've raised a boundary wall in government
To
land?
protect the land. It's
That's
with their
that's still
concurrence.
government land. It's not your land as yet.
Not my land.
No, Milord, Milord.
You were given in principle approval.
No, Milord, because Milord,
And it's
this
a 2
fact was
feet
known to
boundary
them.
wall.
This fact,
To raise a boundary wall.
no, Milord, this
It's
fact
not
was
a
known
boundary
to
wall.
them.
It's 2 feet to
2 feet.
ensure that the
Even if
river.
it is 0.2 feet, sir, the land was not given to you officially?
No,
Not
Milord.
handed
No,
over
no,
to you?
No,
So
no,
how-
Milord, that's.
What authority did you have to raise the boundary wall there?
When we were told that this would be given to you, you apply for long time settlement. We did that. That application is pending. There is a recording. It has to be favorably considered. And at that point of time, we said that, look, the river is breaking this away. So we should make a 2 feet wall to protect the land.
Where is that permission?
There is nothing in writing. So
And Milord, what happened, Milord? Because I am interested to have the land, Milord. I am not interested whether the wall is demolished or not, Milord. So if they want to demolish and tomorrow is grant the land, Milord, then I am agreeable, Milord, because I will have no
Your prayer
objection.
is for execution of the deed in the writ petition.
Yes, Milord, I want to that, Milord. That is my first
First
prayer.
prayer.
My prayer is that. And
First is
then,
keep
then,
effective
then,
the
then, yes, Milord.
long-term settlement.
Then, Milord, I am showing the order, reason for demolition's order, Milord, at page 80. At page 80.
Page 80, it begins at
Page
page
80,
79 bottom.
13 September 2023. Sri J.K.
Yes.
Ghosh, Sri Deepak Shaw, Sri Prakash Banerjee, and 2 others represented on behalf of the Utsav Buildcon Private Limited. Sri Polash Banerjee submitted a written prayer for allowing 3 weeks time, so and so. As per submission, 3rd paragraph. Gone through the letter of the additional secretary to the government of West Bengal Land and Land Reform
You're
Department.
which page?
At page 80, last paragraph.
Yes, right.
Gone through the letter of the additional secretary to the government of West Bengal Land and Land Reform Department by memo number so and so, dated 18th April 2012, submitted by the MB Sponge and Power Limited. It is clearly stated that the undersigned is directed to state that NOC from the Commerce and Industries Department as well as West Bengal Pollution Control Board is sought for under this department's memo number referred to above have not yet been received on this end. This is absolutely contrary to the material record. I invite your lordship's attention at page 57. At page 57. In this connection, second paragraph, in this connections, we are enclosing the photocopies
Yes, yes.
on NOC receipt from the West Bengal Pollution Control Board, as well as the certificate of registration receipt from the Directorate of Industries, Government of West Bengal. Then, my lord, it is therefore requested to furnish the same to this department for further action. From the above mentioned submissions and discussions, it is clear that the LR plot number so and so occupied by MB Sponge Private Limited is unauthorized in unauthorized manner, and LR plot number so and so is occupied by the Utso Buildcon Private Limited without getting permission for long-term settlement from the appropriate authority. Both the companies occupied the vested land in unauthorized manner. Then, in pursuance to second order, in pursuance of section 4(1) of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1962, the Director MB Sponge and Power Limited and the Director Utso Buildcon Private Limited are hereby directed to remove their encroachment as mentioned above by 22nd September 2023, and a copy of such order be served upon all concerned immediately. BLRO Jamuria shall cause an inquiry on 22nd September and send a report to the undersigned on the same day. Failing the compliance of the aforesaid order, Block Development Officer Jamuria Block is hereby directed to enforce eviction as well as removal the aforementioned occupations and get back the possessions of the aforementioned plots on 24th September 2023 and so, that is Sunday, my lord. So my respectful submissions to my lord, that the reason was given, my lords, that I am authorized because I didn't have any no objection certificate from the pollutions and from the Ministry of Commerce. This is absolutely contrary to material on records. So that reason is not tenable. Number second, my lord, that my lord, this order was passed on 13th September 2022.
That is not the reason as recorded in the
As
order.
recorded. My lord, the submission, their
This is only an
submission.
observation.
Yes,
The
my
reason
lord.
is you have occupied without the
Yes,
list.
yes, my lord, that is true, my lord. But my lord, my respectful submissions that the things is going on since 2004, my lord. And my lord, my lord, obtained all the certificate, my lord, from all the authorities, just to, my lord, execute, sign the lease agreement. Why it could not be done? On the basis of the report given by a BLLRO. What he has said that in respect of out of 8.69, 6.2 acres of lands record is not available either in CLRRO or KBRRO. So therefore it could be done only if those land taken in Khutian number 1, because the Khutian number, as your lordship is aware, that vested land always should be put in Khutian number 1. So it would be taken in Khutian number 1 and then grant permission and then grant the lease. So that's only. And they known the fact in every communication, BLRO mentioned the I raised a construction because for my security, because I am having 20 acres, require 21 acres of land, 10 acres of mine. In 10 acres area, my lord, I have already commenced constructions for the expansion and power plant. So the security, my lord, I raised this boundary. Then this fact was known to the authority.
You have raised construction in the government land.
No, this is
Government land.
along with my land.
That has nothing to do with the.
No, only my lord, 0.78 acre this government land. This area only, and this was known to these authorities, my lord, and they communicated in many letters that I raised boundary wall and all this. They have not taken any steps. So only in this hearing, my
Then
lord.
you can communicate that you have raised boundary wall. I
Yes,
did
my
not
lord.
find that in any of your letters.
Yes, my lord. No. Prior to that, there was no communication stating that I have raised constructions on the government land.
Yes.
This is for the first time, my lord. But my lord, in the when
Communications are odd with regard to
in
execution
March
of the deed.
32, I am showing a letter, my lord. In March 32, my lord, in March 22, my lord, BLLRO in a letter stated, my lord, that there was a boundary wall, my lord, in respect of such and such area, my lord. So this fact was known to them, my lord. My respectful submissions is this is not my intention to grab the government land and to put a construction, not that, my lord. If your lordship want, my lord, I can demolish, but I need, my lord, land because I want to set up a power plant, my lord, as well as.
আমাদের আপনি প্রেয়ার দুটো দেখিয়ে দিন, দু রকম প্রেয়ার আছে।
Reply together. Kindly look at
শান্তনু অন্যটা দিন। অন্য petition টা।
yes, below second writ petition page 80.
Already under the boundary wall.
It's a 67.
একবার just pause করে
Act.
Sorry,
Only one, that
very-
later, my lord, at page 67, my lord. This fact was known to them
and March.
on 20th March 2023.
Page?
Page 67
of our writ petition.
of our writ petition.
And one
Yes,
serial
you
number.
refer to this. Yes.
At
No,
page
and
67.
one thing just only,
Just only show, my lord, that
already
this
under
fact
the
was
boundary.
not.
Yes, yes.
The reports were in, but the petitioners MB Sponge Power Limited to LTS because these lands are already under the boundary wall of the company.
So BLRO is saying so.
BLRO
March.
is saying this,
In
and on the basis of that, my other requirement sought for, I complied with this, my lord. So this fact was known to them. It notes that I am going to occupy an unauthorized land, a land, my lord, unauthorized manner. So before applying this act, my lord, my
This is
respectful
not a new
submissions
fact
is
that has
this.
come up.
The admitted position is
So-
I am not the owner of my land.
Mr. Chaudhary, I think please wait for a moment. Let me hear the, because Mr. Bandyopadhyay is appearing in this matter. also?
Only problem,
Mr. Bonga.
is appearing in the first writ petition.
both are
I am
same.
in the second writ petition when
Hey, you
Mr.
submit.
Chaudhary is appearing for the petition.
But if your lordship makes up your lordship's mind in the first matter, I will be completely, my lord, remediless. So that's why I was submitting. Please give me 2 minutes and then
Yes.
for once and
please.
for all, make up your lordship's mind. Let me cover us both.
Yes,
My lord, page 80, my lord,
80.
80. 13 September order. That's towards the middle. Sri J.K. Ghosh, Sri Deepak Ghosh, Palash Banerjee and two others represented on behalf of, this is my client. Palash Banerjee submitted a written time prayer for allowing 3 weeks time for getting relevant documents and information from the concerned department to give suitable reply against the show cause notice which was disallowed. But after that, they submitted a written reply to the show cause without any annexation. In the reply, it was stated that for the purpose of expansion and setting up of integrated steel captive power plant in such and such, a land measuring 18.88 acres have been applied for long-term settlement before the office of the ADM DLRO dated 9th April 21. Pending for below 2 years now. As per the submission made by representative of the above mentioned companies, that they prayed for LTS and after submission of that prayer, they have started for construction of wall. They not only constructed wall over the vested plots, they purchased Rayati holdings, erected boundary vested plots between them. They just continued their erection of wall with an approximate length of 300 meters through LR plot number such and such, which is partly occupied by the company. So, my lord, this is going on for more than 2 years now. My lord, we had identified land and to set up a captive power plant. Now, on one side, my lord, is a nala or a small river. Next to that is government land. Next to that is other land, which we have acquired because the government, my lord, told us that we'll give you this land. It's our land. There are certain procedural hiccups as by Learned submitted. This is not in Khotiar number 1 yet, so it will take a little government thing, it takes a little bit of time. So, my lord, we were over there, we are setting up our plant. Now, water is, my lord, eating away the land, which is why we built a 2-foot high, my lord, wall on the government land. It is government land for which I have applied for LTS. Till now, there is no refusal, there is only consideration. This was the situation, there would have been no problem. This would have been worked out. I expect to get my LTS because I am certain, my lord, that if I am setting up a plant which will employ 10,000 people, I will get, my lord, that little bit 18 acres of land or whatever. This is good. The total plant, my lord, will be over 50 acres of land. So 18 acres, I am expecting to get it. Now this wouldn't have come to court. The problem was somebody went and filed a PIA and considered representation order was passed. Now when this considered representation order was passed, the authorities are also now under pressure. Till now, my lord, they did not, they knew that this would happen, so nobody bothered because we built a 2-foot high wall to prevent land breakage into the water. So now what happens is, this thing has come up on their head. They cannot say that we will not Next steps. So they called for a hearing. Chief Justice's bench of the High Court, my lord, has directed immediately to it. So they do it. On the 13th, we request for an extension. And we said we'll submit all the documents and in the meantime, try and expedite and see if I can get the LTS formalized. Because once I get that, this complaint is meaningless. But immediately 13th, my lord, under pressure, order is passed that we will demolish. Order may not given to us yesterday night for demolition. This is my lord the situation. Now, two things. No enforcer, my lord, can seek equity before your lordship. I am not, my lord. I want to give, my lord, two undertakings. Number one, if for any reason LTS, my lord, is not granted in our favor, I will immediately vacate this land. I'm not, there's nothing on this land. I've not made any construction on this
In the
land.
first place, it could not have been occupied without an
I
LTS.
am not occupying. Really speaking, I'm not occupying. My plant is, my lord, behind that. I have put up a, now, my lord, kindly look at why I have put up a wall. Your lordship is right. I'm not saying, my lord, it's inconceivable. I've put up construction on government land, whether it's 2 foot, whether it's 20 foot. It is construction. There is no legal right. It has to be demolished. This is, my lord, the situation. But somebody coming, bona fide applying for LTS on the land, being assured, which is why I go and acquire land at the rear. That's why I'm setting up a mega power plant, my lord, there, the cement grinding plant. That's why, because of that, so my lord, there is something. Now, my lord, kindly see. Below that, my lord. As they've started, they've not only constructed wall over the western plot, they purchased Rayati land, continued erection. Then gone through the letter of the additional secretary to the government of West Bengal. It is clear that the undersigned is directed to state that NOC from the Commerce and Industries Department as well as West Bengal Pollution Control Board is sought for under this department's memo.
The same order that was read out.
Yes,
Yes.
same
That I
order.
have shown that we have already obtained these two certificates.
Have not yet been received, so that's also awaited. Now, the reason is, my lord, this is for the protection of the land. Now, kindly see page 78.
Mr. Chaudhary, let the government protect their own land.
But this
You
is,
still have no locus.
I do, my lord, I agree. Only one thing, my lord. Maybe, my lord, on a natural justice issue, my lord, I can defer the demolition for at least 7 days and I can utilize those 7 days to get some things from the Ministry of Commerce and get it. my lord,
Demolition is of the wall, nothing else.
Nothing else. So there's nothing else.
They are talking about another, talking about removal of encroachment.
Yes.
Since you say that there is no further encroachment on government land, so what is disturbing you?
Now, what,
No,
what
my
I tell you, lordship,
no,
what
my lord, my districtful
And if
submission.
you have actually made constructions on government land, that is required to be demolished. Irrespective of whether you are entitled to the lease or not.
No, my
Because you have
district.
done that in an unauthorized manner
Yes,
prior to granting of the lease.
yes, but
So you
I
cannot claim any equity.
No, I cannot claim, but one thing I cannot claim that if my lord, I am asked to my lord, give reply for show cause. One day I appear and I request for some time. Then my lord, that day itself refused and order for demolition and eviction passed immediately. That order is not served for my lord 12 days. And is served one night before the demolition, which robs me of my chance to find all that I'm playing my cards on the table.
After your show cause notice was disallowed.
Yes,
time
no,
where
not disallowed. Miller, please see the sequence of events. 13th September, I am asked to be present with a reply to a show cause. I go there and I ask for time. Time is, prayer for time is rejected.
After that, you filed a written
No, I filed a one
on
page.
the same day.
One page, I have annexed it, but I couldn't produce a single document. I can argue estoppel, I can argue promissory estoppel, legitimate expectation. I am entitled to argue. But my lord, on 13th of September, My prayer is rejected. Immediately demolition order passed, and this is not served. This is served on 21st for demolition on 22nd. So I have a right of appeal under the Act, my lord.
Sure.
My lord, appeal is under section 7 of this Act, my lord. I have 15 days time to file an appeal. All that I am asking for is that 15 days. No, I am not.
Under the 62 Act.
Yes, my lord. I am not, my lord, trying to justify my wrongful act. But if I get this time, I may be able to convince the government. This 15 days is what I am asking for. Let me file an appeal. In the meantime, what will I do? I'll go to the Ministry of Commerce and say that, look, I'm building a plant. You have to do this. Now, under pressure, they are demolishing the wall, which will take the land away. Please don't allow this to happen. Second, this goes away, 4 encroachers will come in and sit. This is blackmail. Your Lordship can understand. Break the guard wall. Somebody comes in, sits to remove him, because I need to remove him. Otherwise, I'm setting up an industry. When you're investing 1,000 crores, you wouldn't mind paying somebody 50 lakhs. 10 people will come in, put up 4 jhobarpattis, more blackmail, then pollution control board, then labor problem. The problem with us is this is why we are where we are today.
Like the other writ petition, have you also submitted those pollution control board certificates and all that?
Yes, my lord.
That was called,
yeah,
no,
yeah,
no, in the second writ petition.
yes, my lord. No, no.
We have not been able to put it because we got this yesterday evening.
Let us hear the government. Yes, Mr.
All I am asking, my lord, is give me 10 days time. I will get it
The appeal period.
regularized. If not, then demolition. And government should, my lord, support us instead of opposing.
Yes, madam.
There is substance in the last leg of your submission. So let's see.
Support us.
I'll come to that last leg of resumption later. I'm deeply,
The appeal period.
the people, right? I'm deeply indebted to your lordship, because all along your lordship was of the view that whether they have the locus standi to maintain this writ petition at all or not, because they have encroached over a government land, admittedly a government land. They have admittedly constructed a wall therein. And my lord, if your lordship looks at the order, my lord, they have also tried to force certain signatures of certain riots. And those are all scheduled caste persons or backward classes persons. So that is all the more offensive when scheduled caste, scheduled tribes lands are sought to be, my lord, your lordship knows very well, are sought to be taken illegally. Talking about legitimate expectation, talking about estoppel, promissory estoppel, none of these factors could come into play in this particular case, my lord, because they have no right whatsoever. There is an order passed by this honorable court in a public interest litigation. We have acted in compliance of the order. We have duly afforded them adequate opportunity of hearing. And after that, an order was passed. And when steps are being taken for execution or implementation of the order, then they comes up before your lordship, files a writ petition, seeks your lordship's indulgence to move it unlisted, my lord. We are there before your lordship. Now your lordship sees whether we, my lord, have violated this provision, section 7, by not allowing them 15 days time to prefer the appeal. Appeal is from an order, and the order is of 21st of August 2023.
Was it served?
It was served on 21st of August,
Where
my
is the
lord.
document?
My lord, that is the document. If your lordship kindly, the first writ petition, or if your lordship kindly says the second writ petition.
Anyone.
Go to the archive.
To show in both of them. Yes.
28th of August 2023, if your lordship sees.
The order was passed on 13th September.
No, this is order for execution of that 21st of August. Well, that is what I am on. If your lordship kindly sees, if your lordship is taking up writ petition number, that is what the confusion is sought to be created.
You're on the first writ petition.
I'm with both the writ petition. I'm with both the writ petition. If your lordship is taking up 23195 or 23199,
And
whichever.
the first one.
23195. 23195. The order is of 21st of August 2023, which is at page 75. They themselves have annexed that order. This is the order. Notice duly served. May I place that entire order, madam? This is very vital.
Yes, the case is disposed of, yes.
Well, as such, the order is hereby made to cause demolition of illegal construction and eviction of illegal intruders and government vested lands under the provision of the West Bengal Public Land Eviction of Authorized Occupants Acts, and the subdivisional magistrate is hereby directed to initiate the necessary proceedings as provisions of the aforesaid act. The order was passed on 21st of August. It was communicated again on 28th of August for compliance, for implementation of the order under section 3. Under section 3, that is the notice at page 78. My lord, they will get, they have got impelled opportunity. I am facing the stalwarts. I am facing the stalwarts. Yes, you were there. On 21st of August, your lordship kindly cease. Then my lord, I'll place that order, my lord, page 75. At page 75. Notice duly served, service return filed with the case record, attendance of the parties to the writ proceeding have been duly recorded, and written statement from MB Sponge and Power Limited and User Polycol is kept as a part of the record. The written statement submitted by MB Sponge and Power
You have again issued a show cause notice after that order.
for demolition because they have not acted upon this order. Thereafter, at page, your lordship kindly comes to page 78.
Upon the petitioners.
No, 78, if your lordship kindly comes upon. 78, notice in
It's a notice
compliance.
of- A show cause to the petitioners.
So, no, the order was communicated to them. The order was communicated by this correspondence. If your lordship kindly sees.
Which correspondence?
In steps under this act was initiated.
Lordship kindly sees. Oh, that is, my lord, because they have mixed up the paper. Lordship kindly takes up the second writ petition. My lord.
Second writ petition.
Second writ petition.
Yes.
Yes, my lord, that in due compliance with the order passed by the
70.
My lord, your lordship kindly sees page 67.
Of the second writ petition.
Page 67.
Yes.
This is communicated to both the writ petitioners. Number 2 and number 3. Apropos to the subject captioned above, this is to inform you that in terms of the solemn order dated 6th September, passed by justice in the matter of the state, the proceeding was initiated by the undersigned and the same was disposed of on 21st of August. The plain copy of the order passed by the undersigned is enclosed. And this is dated, my lord, that on the top I'm not able to find the date because that this is dated 1st of September 2023. Lordship has seen the date.
Siddiqui, this is issuance of the notice. Where is the service?
Oh, this has been served upon them. They have annexed it.
Copy of the order to.
So this is the writ-
They have annexed it, my lord. They have annexed it. My lord, I'll tell you, lordship, what is happening. My lord, I am told by my learned friend now, a contempt petition is pending before the Honorable Chief Justice, my lord, division bench in connection with the public interest litigation because they have encroached over a vested land. Now, to avoid all this proceeding, they did not took out any application for addition of party before the Honorable Chief Justice, saying that we are rightfully entitled to encroach over that land. That is the expression which I am supposed to use, my lord, because they have unauthorizedly occupied a government land. That for that purpose, the proceeding under the West Bengal Public Land Eviction of Unauthorized Occupants Act was initiated. Order was duly communicated to both the parties. They have annexed it at page 67. Thereafter, when the order is sought to be implemented, my lord, if your lordship sees at page 78, no, ekhane 78 no, sab page number to milche. 76, or 72, my lord, they, my lord, do not want to get this encroachment removed. They did not prefer an appeal. Then they comes up before your lordship says that you have not given me any time to prefer an appeal. And now, my lord, they have filed this writ petition.
Page 71, this proceeding is directed to be started. What is my?
Disposed of. The language is very clear. 67, my lord, has sent disposed of.
Made to cause demolition of illegal construction and eviction of illegal intruders under provisions of such and such. Subdivisional magistrate is directed to initiate necessary proceedings.
Yes, and the case is disposed of.
Proceeding when I am going to.
No, that is the, my learned friend is possibly not aware of the orders passed under the West Bengal public land. The case has been disposed of. The order has been passed by the collector and an appeal lies against the order of the collector before the commissioner. Before the commissioner of the division.
My lord, I have only been.
Order is by the ADM DLLR.
ADM DLR. That is the collector. So the appeal lies before the.
It's not the collector.
No, he's the collector. Then he's the key over it. The collector. The collector, where the order is made by an office, where the order is made by. The appeal goes to the collector, where the order is made by the officer specially appointed under subclause B of subclause 1 of section 2. So he has to go before the collector.
Absolutely.
And that period of appeal has long gone.
No,
That is the order which is to be
Because
appealed again.
order was served yesterday, so that within 15 days.
I think.
And that depends.
And this is the order for breaking of the wall, for demolition of the wall. They have come up before your lordship that the time limit for appeal. My learned senior friend did not say about this.
13th September.
No, it is there on the record. It is there on the record.
13th September order is under section 4.1.
4.1, my lord. 4.1.
That is in respect of in my petition, page my lord 79.
That is the eviction case.
That is eviction case, my lord. And compliance case, my lord, as page 73.
Lordship will save below 10 minutes.
Page 73, page 73 and 79. Completely two different proceedings. One is compliance proceedings and another is my lord, eviction proceedings.
Compliance of the order. Compliance of the order. Very good, my lord. I'm grateful to.
I'm afraid. One order is on the 13th September.
4.1 order. If after considering the cause, if my lord, I'm just placing before lordship. If after considering the cause, if any shown by any person in pursuance of a notice issued under section 3 and any evidence he may produce in support of the same, and after giving him a reasonable opportunity of being heard, the collector is satisfied that the public land is in unauthorized occupation, he shall make an order of eviction directing all persons in such unauthorized occupation to vacate the public land and deliver possession thereof to owner within such time as may be specified in the order.
This is the final order.
My lord, this is the implement.
Section 4 is the final order.
My lord, I have already passed that order. If this is section 4.1 order.
Initiation of proceedings is different from passing of a final order.
But
Don't mislead this honorable court, please.
sorry, he raised that point, please.
Okay.
Since Mr. Siddiqui, my lord, has said that I have raised the point, I only request for 1 minute. I'll explain. The lordship, the division bench passed an order for consideration of the matter. Then, my lord, kindly now take page 67 of my petition.
Which one?
Second petition.
Yes.
After that order, a proceeding was commenced, my lord, by the ADM and DLRO. That resulted in the order which Mr. Siddiqui, my lord, was referring to. The concluding part is at page 71. The ADM LRO found that my possession is unauthorized. And, my lord, please look at page 71. Last 3 paragraphs. There is encroachment, such and such, as such order is made to cause demolition of illegal construction and eviction of
This
illegal.
is initiation of proceedings.
Yes, then he says, next sentence, so therefore, I prima facie form the opinion, so therefore, start proceeding under the West Bengal Public Land Eviction of
No,
unauthorized
this is under
occupants.
section 2.1b.
Now that proceeding results in the order which was communicated yesterday.
in charge.
And from that order, I have a 15-day right of appeal. So, my lord, we've just given the brief in the morning, my lord. After that, being in Mr. Siddiqui's shoes for 5 years, I know he must have got it by 12:45. So I'm really trying to assume.
একটা 45
No, my lord, I got it at 2 o'clock.
Prime of even
I got it at 2 o'clock. My lord,
Under 3 government leaders, I have lived for 5 years.
and I've spent almost 11 years now. My lord, this is not 4.1, my lord.
one is yes.
This is not 4.1.
The last one is.
For company
My lord, I'll come to that. I'll come to that.
81 is 4.1 order.
No. If your lordship, I'll just read the entire order if your lordship kindly allows me to, my lord.
Lord, may I have?
My lord, I'll take your lordships, my lord, to page 79. To page 79.
Second interpretation order bolo
Of the writ petition which Mr. Chaudhary was making submission.
Yes.
My lord.
79.
79. My lord, nature of the case, compliance of the order. If your lordship sees at the top, my lord, before that tabular column.
Yes.
Nature of the case, compliance of the order dated 21st August 2023 of learned ADM and DLRO Paschim Bardhaman in connection with solemn order so and so. Now, my lord, 28th August, whereas it appears that in compliance with the order so and so and so and so, the ADM and DLRO passed an order on 21st August, which has been received by this office on 25th August. Whereas it further appears from the aforesaid orders that the encroachment and unauthorized occupation over LR plot by this and this company, both the companies. In view of such encroachment and or unauthorized occupation over the government land, the instant proceeding is been drawn under the provision of the West Bengal Public Land Eviction of Unauthorized Occupation known as West Bengal Act 13 of 1962. Now, the understand being imposed under section 2(1) of the Act and as per provision in section 3(1) of the said Act, a show cause notice is required to be issued upon such occupants, providing them an opportunity to show cause. Issued notice to show cause on submission of reply. DA is asked to miss the case. So show cause was served to them on 13th/9. 13/9, my lord, they appeared.
Proceeding is still going on.
The 13/9 they appeared, my lord. I will not trouble your lordship with the entire, because this has been read again and again. Then we come to the last page, my lord, page 81.
Yes.
In pursuance of section 4(1) of the Act, both this company are hereby directed to remove their encroachment as mentioned above.
So this is conclusion of the proceedings.
I leave it to your lordship.
Thank you.
But my lord, they have no case, and I have been told, my lord, contempt proceeding is pending before the Honorable Division Bench.
Contempt proceeding to what? I want to see
My
the
lord,
order.
in a public interest litigation, that these encroachers are very well enjoying this particular land. He has found out that order.
Because I am given to understand that public interest litigation. Will you come back next week with the orders? I want to see the Chief Justice's order.
My lordship may kindly, my lord, because
Chief Justice's order is
my lord,
part of
my lord, if your lordship, my lord, I will just, my lord.
The second writ petition, which is at page 61.
61?
61 is the division bench order. The second writ
Mr. Dhar is appearing, I am told, my lord, in that public interest litigation.
61 is below the order of the division bench. That we may consider represent.
I'll just, my lord, humbly beseech your lordship, my lord, if at all, if,
That grievance raised by the petitioner, please come to page 64. 30.49 acres of government land is being grabbed and filled up by fly ash of factories.
my lord.
So that has nothing to do with raising of the boundary.
No, MB Sponge Iron, my lord, they are using that fly ash. For this fly ash is used for this for industries, my lord.
Raw material, as a raw material.
They are entitled to a statutory appeal under section 7.
That appeal I am telling, my lord, but that is there. But fly ash, my lord, is a very, my lord, this is also very important from the pollution aspect, my lord, because this fly ash.
Here the these petitioners are not named.
No, these petitioners were there in that. My lord, we are not aware whether they were party or not, because they have annexed. I was not. But when they are aware that there is a public interest litigation and an order was passed, they have themselves annexed these orders of the public interest litigation. They ought to have taken recourse to approach the Honorable Chief Justice's court, saying that this order is affecting us. Because in compliance of the order passed in that public interest litigation, my lord, all these steps, in compliance of the orders passed in, in compliance.
Contrary to record.
My lord, I will take a lordship's leave.
Never will not come to the fly as Lord. What submissions
My
you are
lord.
making before the court? Anywhere in your any communications, you have raised this allegation. You are telling something.
Just please give us that.
My lord, 15 days time is there, my lord, to prefer an appeal. 13th of September, this order was passed. They are saying that it has been, my lord, I take it from, my lord, again, my lord, I take it from them that it was communicated to them yesterday. I'll take it that it was communicated to them today, my lord. Kindly grant them 15 days time from this date, my lord. Only 15 days time, your lordship kindly keeps the writ petition pending.
No coercive action.
No coercive action. But that, my lord, that 15 days will be a peremptory direction, my lord. In within 15 days, my lord, no appeal is preferred. My lord, then the authorities will be at liberty to take steps, my lord. I'm grateful to your lordship. May I take your lordship's leave, my lord? I'm grateful.
I am grateful to Mr. Siddiqui.
Shall I record your submission, Mr. Siddiqui? Shall I record your submission? No.
My lord, your lordship may kindly record that this writ petition on the face of it is not maintainable, because, my lord, admittedly, they are the encroacher over the government land. It is a wasted land, and admittedly they are the encroacher over the government land. And by making an application for long-term settlement does not grant them any right to encroach over the government land.
One in respect of that order, my lord, which was passed against me, my lord. And the second demolitions, my lord. And the second, my lord, to grant land, my lord, for long.
And no. Both cause of action cannot be, my lord.
It's the prerogative of the government. This court will not give any direction.
I'm grateful.
Prerogative, my lord, if I fulfill.
I'll protect you for 15 days. This court will protect you for 15 days. Please take necessary steps.
That is
That is
If
If they can go and manage and get it done, they'll get it done. Otherwise.
You've used the wrong term.
Yes.
You've used the wrong term.
Otherwise, guard wall goes.
No, I have asked for implementation of memo.
From all these communications, my lord, which I have placed before your lordship, my lord, that because, my lord, that the government is agreed, my lord, I fulfilled all the terms and conditions. What wrong, my lord? Why, my lord, this matter is pending for the years? Government cannot
sir.
take any arbitrary actions, my lord.
You should be happy with the protection.
Yes.
For the,
The petition, একই order হবে দুটো। আলাদা আলাদা order হবে কিন্তু same order হবে না। The petitioners এটা কোন heard learned counsels for the parties. এদের না first of it. Heard learned counsels for the parties. It is contended on behalf of petitioners that the petitioners applied for long-term lease before the government in respect of the plot in question. Upon obtaining no objection certificate, this was obtained by in the second petition also, I'm sure.
No.
Upon obtaining no objection certificate from the
It was submitted, they have not got any permission.
Because it was drafted in a hurry, I am not
So
very
I'll not,
sure what we have, my lord.
কি বলো? The petitioners upon obtaining plot in question for carrying on business therein,
My lord, may
which is
I
under
make submission because of,
consideration by the government. Stop. Yes,
because the factual aspects, my lord, might be different, my lord, from the two. So, my lord, I need, my lord, your lordship's, my lord, some findings, my lord, on the basis of my facts, my lord, which are placed.
and I'll record your facts in your.
I respect
I'll
your
record the
subject.
facts.
Yes.
Yes. The petitioners obtained no objection certificates from the from Jamuria municipality, Jamuria municipality and Hizalgora, Hizalgora, Hizalgora Gram Panchayat for the same, which was communicated to the government.
My lord's deep.
The additional district magistrate and district land and land reforms officer, Bird 1, by a letter issued on 15th November 2007.
And also
to
from
the-
West Bengal Pollution Control Board and Director of.
I'll come one
Yes,
by one.
yes.
To the Joint Secretary, Land and Land Reforms Department. Requested the latter, LATTR, to consider the proposal for long-term settlement of government vested land in favor of the petitioners upon consideration of the documents including the project report, calculation sheet, resolution of Bon o Bhumi Sanskar Sthayi Somiti, Jamuria, NOC of the Panchayat, NOC of the municipality, and vetted sketch map and Khotian. Stop. The NOC from the Commerce and Industries Department, Government of West Bengal, as well as the Pollution Control Board were also submitted by the petitioners before the authority. By a communication made by the Additional Secretary to the Government of West Bengal to the petitioners, it was informed that an area of 8.69 acres of land was available for settlement instead of 9.79 acres proposed earlier. And the same was accepted by the petitioners. Since no further step was taken by the government in this regard, the petitioners, by a letter issued on 25th July 2022, requested execution of the long-term lease in their favor. A letter issued to the Additional District Magistrate and District Land and Land Reforms Officer, Paschim Bardhaman, by the Block Land and Land Reforms Officer, Jamuria, on 20th March 2023, demonstrates that the land for which the petitioners applied for long-term settlement was already within the boundary wall of the company. Stop. As per office records, no record was found in respect of plot number 1771 Stop. 2.50 acres of Rayati land was found in the records, but there was no record pertaining to 6.02 acres. The Block Land and Land Reforms Officer sought permission for inclusion of plot numbers 1771 and 1798, as well as 2027, 1771 and 1798 of Moja Hijalgora, and plot number 2027 of Moja Ikra, IKRAH, in the collector's Khotian, that is Khotian number 1. so that the plots could be recommended for grant of long-term mining lease in favor of the petitioners. Long-term lease in favor of the petitioners. Paragraph. Public interest litigation was filed before the Honorable Division Bench dealing with such matters, alleging encroachment and illegal construction upon government land, which was disposed of by an order passed on 6th September 2022. Where is the order of the public interest litigation?
Milord, that is in the second petition. Milord,
Second petition is there.
Page 61, second.
Which was 2022, permitting the petitioner therein to file an appropriate representation before the fifth respondent and a direction upon the fifth respondent to consider the grievance of the petitioner and conduct an inquiry, if required, and take appropriate decision in accordance with law within 3 months from the date of receipt of the representation. In compliance with the said order, and upon holding the petitioners to be encroachers on government land, proceeding under the provisions of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, 1962 was initiated, and notice under section 3(1) of the Act was served upon the petitioners. Upon hearing the petitioners, the subdivisional magistrate, Asansol, Paschim Bardhaman, by an order passed on 13th September 2023 under section 4(1) of the Act of 1962, directed the petitioners to remove their encroachment from the government land within 22nd September 2023, failing which the block development officer, Jamuria block was directed to enforce eviction as well as removal of the aforementioned occupation and restore possession of the plots followed by a report to be submitted before the subdivisional magistrate. Paragraph. Learned counsel for the petitioners submits that the order was communicated to them yesterday, that is, on 21st September 2023, and the date of demolition has been fixed today. Stop. The petitioners seek an opportunity to prefer an appeal against the said order under section 7 of the Act. Paragraph. Learned counsel for the state respondents submits that the petitioners have encroached upon government land by raising a boundary wall therein prior to grant of lease in their favor, and as such, have no locus standi to claim any relief in the writ petition. Stop. The petitioners are admittedly encroachers in respect of government land and cannot claim any relief herein. That is your submission, Mr. Bandapati.
Yes, yes.
Yes.
This is yes, but only thing, madam, the already contempt proceedings has been initiated in violation of the order by the Chief Justice. That may be recorded. That is the difficulty, madam. I have just been informed that, madam, there is an order saying that till you disposes the persons, the compliance, you have not complied with the order. I have been told this. This has been informed, but order has not been uploaded. That is the difficulty, madam. Till people have disposed the contempt stays. That is the difficulty, my lord. Kindly consider.
Milord, I have checked the order, Milord. I have checked the website, Milord. I have only seen, Milord, that this matter came up for compliance. So order has already been complied with. So therefore, the contempt court is a consideration order. Contempt court, I think, will not proceed further. So what my learned friend is apprehending.
My instruction that, but I can read 5th September done. Order is not uploaded in this. Speaking as there is an encroachment in the government vested land until and unless eviction completed, compliance is not done. Now, this is what I have been
Is
forwarded.
the order of the court or the?
But this is a version. But now it is live. YouTube, all possibly this was observed during the hearing, and thereafter the. But I cannot vouch for it. I was not present. That is my difficulty.
I'll only record that contempt is pending.
Contempt.
Learned counsel further submits that a contempt application in connection with the order passed in the public interest litigation is pending. Paragraph. Section 7 of the Act of 1962 permits the petitioners to prefer an appeal from an order made under this Act within 15 days from the date of the order appealed against. Paragraph. Since the order was communicated, since it is not in dispute that the order was communicated to the petitioners only on 21st September 2023, the petitioners are entitled to prefer statutory appeal against the said order within today is Gosh, huh? So within 5th, yes, within 5th October 2023. Stop. Paragraph. In the event the petitioners preferred the statutory appeal within 5th October 2023, the appellate authority shall consider and dispose of the appeal within 2 weeks. Yes. Within 2 weeks from the date of filing thereof, in accordance with law. stop. If the petitioner fails to prefer the appeal within the said period, comma, the respondent authorities shall be at liberty to take necessary steps in terms of the order dated 13th September 2023.
Yes.
With the above observation and direction disposed of.
In my prayer, Milords, I have already, prayed for a writ of mandamus, Milord, regarding the long-term settlement, Milord, on basis of these facts placed before your lordship. If some observations, if it is not, Milord, if
I
it
have
is,
recorded your
yes,
observations.
otherwise,
nothing
Milord,
more,
they will
nothing
say
more.
that it was considered and the court didn't pass any order. So they'll interpret in this manner, Milord, then our right to, Milord. Otherwise, Milord, so therefore, Milord, I am afraid of that.
Litigation is pending. You have been held to be encroachers.
No, that's
So now
right,
it is
Milord.
for you to approach the authority. No further direction will be given by the.
Interim order till. Malad has protected.
I have stated
No,
15 days.
15 days.
15 days and appeal will be disposed of within 2 weeks. So no coercive action till disposal of them.
Well, till the date of filing, Malad, let them approach and pray for the same order before the authority. The
Yes,
authority has the
Milord,
right. Malad, when preferring an appeal with the, but they have a right to pray for interim order. They should prefer file an appropriate
No,
application.
Milord, right to final order, interim order shall continue.
They should.
Why does the disposal of that?
Be taken against the petitioners in respect of the plots in question till disposal of the appeal. I have
Well,
given
till the
2
2 weeks, 2 weeks.
No, Milord.
Statutory appeal.
Yes.
Within 2 weeks, it will be disposed of.
Until
I've stated that.
And my lord, no unnecessary no unnecessary adjournment should be given. Because but if they but the
That is
order
for the appellate.
my lord, no interim order is been extended till the disposal of the appeal. My lord, if the interim order was till the 2 weeks after filing, my lord, I would not have said anything. And that's why I'm saying. Till disposal, that is a difficulty. My lord, would kindly make
In it, the appeal has to be concluded within 2 weeks.
For disposal within 2 weeks.
2 weeks.
Whether or not the petitioners appeal.
And the interim order shall continue to that extent.
So authority
You
has to approve
dispose it by 15 days.
No,
Till disposal.
disposed of. Second rate petition, these facts will not be included.
Yes, the only thing, Milord, I have applied for LTS, Milord, on 9/4/2021, Milord, and I have acquired purchase. In between the proceedings happened, Milord.
Second না আলাদা করে দেবো না সেম মাঝখানে টুকু হবে না স্টেটের যেখানে সাবমিশন ওখান থেকে
Milord, otherwise, Milord, one minute.
স্টেটের সাবমিশন
Otherwise, they will not consider our prayer because of the rest.
That 1 minute.
Not pressed order, not press করে দেন এই prayer যেগুলো implementation চাওয়া আটকে যাবো পরে
for carrying on business therein
বলে দিন
which is under consideration by the authority
authority for considering our prayer in accordance with
no further communication was made by you with the
No.
On LTS, Milord, I have made an application, Milord, and thereafter, on the basis of assurance, I have started procuring direct purchase from the large client. Thereafter, Milord, we have started just now. My landed friend client is the old Milord factory there, and then Milord, this proceeding initiated and
on the basis of assurance given by the authority for grant of such leaves, the petitioners to raise the boundary wall. The petitioners.
I have said, Milord, the guard wall, not the boundary wall.
The petitioner raised a guard wall surrounding the proposed leasehold property in order to protect the property from being washed out by the canal which flows adjacent there. That is your case.
My case is that I have constructed the guard wall on my land. Some portion
No,
may have
on the wasted land that was submitted by Mr. Chaudhary. On the wasted land, my lord, what my land?
The canal, the government land, then your land.
Yes, but
And the boundary
what I'm
lines,
trying to
yes.
say, the entire boundary wall is not on the government wall land. My land, some portion has been, transferred.
তারপরে ওই এটা চলে আসবে পাবলিক ইন্টারেস্ট লিটিগেশন কি বলেছি আগেরটাকে একটু বলুন আমি ওখানটাকে দেখবো
Not going into the
Yeah.
landscape token. Correct. Not going to the-
স্টেটের আগে
Not
স্টেট
press
পুরো আসবে যা আছে
That's.
তার আগে
Let's consider our application recommendation in accordance.
এগুলো আসবে না এগুলো কিচ্ছু আসবে না। আমি যেটা বললাম তারপরে পাবলিক ইন্টারেস্ট লিটিগেশন ওখান থেকে পুরোটা আসবে পাবলিক ইন্টারেস্ট লিটিগেশন থেকে পুরো সেম হবে না। শুধু ফার্স্ট প্যারাগ্রাফটা চেঞ্জ করলাম হ্যাঁ হ্যাঁ শুধু ফার্স্ট প্যারাগ্রাফটা চেঞ্জ করলাম
Only one addition may be made, this order, will not prevent from considering, otherwise, constructive red judicata might be. Then I will not praise this prayer, either two things, either your lordship pass an order, that this order will not prevent the authorities from consideration.
একটাতেও করুন দুটোতেই করুন লাস্টে করুন ওই shall be at liberty করুন disposed of ঠিক আগে করুন however this order shall not preclude the authority from considering execution of
Granting long-term settlement.
in favor of the petitioner.
Yes.
First a petitioner, second a petitioner.
I'm grateful to your lordship. I'm grateful to you.
Group 7 matters are all gone. ঠিক আছে।
এটা চেঞ্জ করে দাও পাঁচ মিনিট চলো Group 7 motion, item number 309.
5 minutes of the.
You don't want to do?
1.5 hour. Yes.
More so, Mera, the yes, more so, no one is appearing on behalf of the state. Next Monday, though I have no grievances against this, the Ibrahim's client having no grievances. But here the Bihar. So someone is to appear, man, and no one is appearing.
Hearing matters? All three are your matters. And there is no one for the state.
No, my state is there. I think Mr. Debra is appearing for the legal metrology. Railways.
Group 7 hearing, item number.
I am for the petitioner. Yes.
Friday
she will-
afternoon.
Lordship will remember this is the matter. I have completed my portion of my submission.
Railways,
Railway now it is up to the legal metrology and the railways to make their further submission.
let me just make it not today.
They kindly make it not today only. The legal metrology has already, their statement is here, my lord.
That supports your case.
That supports my case because railway itself admitted my contention that it is the way bridge is out of order. So, and made an application before your lordship seeking a direction upon the legal metrology to rectify it.
Now, on the basis of that, my lord, joint report was published where it was again revealed that the said machine is non-functioning. Now, that is, and after the payment was undertaken, my lord, will remember there was an direction upon the railways to conduct a payment of the tier weight, that again the defect arose. So, as per the Honorable Division Bench's order, my lord, Lordship is aware of that order. I have placed that before. I am entitled to the punitive charges, which I have deposited with them without prejudice.
For refund, yes.
Yes, I am asking for refund. Because I have only to have to demonstrate before this honorable court that the weigh machine was not functioning properly. And that before I can say, my lord, the railway themselves have said so.
But
And
who is appearing for the
the
railway?
railway, Mr. Shanojit Ghosh, is appearing for the railways. I have completed my submission. I have placed those judgments also.
Just make it not.
Make it not.
It automatically appears on the next.
Okay.
All three are similar matters.
No, my lord, different.
Not true. 23 not true. Forest and other.
124.
This is my writ application.
Ready?
Not today, just our Mongolbar.
Only not today.
Sir. Next one.
No, next one.
No.
Earlier.
My lord, this is a matter. Lordship will remember this pertain to Lordship, one agreement has been executed with the Southeastern Rail. Now, I commenced my operation, and after commencing the operation, my lord, I faced certain inconveniences. That is, I have to load 23 tons of parcel cargo in a parcel space, for which I required time. The time has been provided as per the agreement that if there is a siding, then I will be given a 3 hours free time. If there is no siding, then what is the available time which I get? I have to load, unload within that time only. Now, my lord, as I was not being provided with the sufficient time, despite there being a terminal at the Southwestern Railway, my lord. So I made a representation before the competent authority here, because Southeastern Railway is the zonal authority who has issued the tender. And zonal authority, my lord, the Southeastern Railway wrote a letter back to the Southwestern Railway that if such facility exists, then you have to do something so that this problem can be sorted out once for all. Now, my lord, despite the interdepartmental communication, that was not given due weightage. Now, thereafter, my lord, I made another representation. That representation was followed by another reminder from the Southeastern Railway to the Southwestern Railway to provide the basic facilities. But this is the facility because, my lord, 23 tons capacity, my lord, is just equivalent to 6 lorries, my lord. That takes time because I have to load. First I have to unload. Then I have to load. That takes time. It's not possible, lordship, in a platform to load, unload the entire consignment within the time specified. Because when I am paying the freight at both the ends, that this is the basic minimum requirement which is required. Because until or else, my lord, the entire contract gets frustrated. Now, my lord, kindly come to, then, my lord, finding no other alternative, my lord, I wrote a letter to them that if you do not sort out my issues, it is no point in continuing with it, because under the agreement, there is a provision for suspension. I have invoked that clause, and I have wrote a letter to them that from 30th of May 2022, I will not going to operate further till the problem is resolved from your end. And thereafter, my lord, a considerable period went by, nothing came from them. I approached before this Honorable High Court, my lord. This Honorable High Court, my lord, passed a direction. Lordship will kindly come at page 75.
Yes.
This is the second round of litigation, my lord. After that order was passed. May I read, my lord, page 75. Learned counsel for the petitioner contends that despite having come out successful in a tender and having been granted a lease for loading and unloading of goods in railway carriages, the petitioner, due to the laches of the railway authorities, was not getting the minimum required time even to unload the goods from the said carriages, let alone load thereafter. It is argued that on occasion as less as 15 to 30 minutes time was given to the petitioner, whereas at least 3 hours are required to properly complete the unloading operation. It is submitted that as a result of such predicament, the petitioner communicated specially to the railway authorities, in particular the senior divisional commercial manager Bengaluru and Kharagpur division, indicating that petitioner were being compelled to discontinue the leased LVBH in train number such and such. Despite repeatedly having communicated to that effect to the railway authorities, all of which were acknowledged by the railways, it is contended that no steps were taken by the railway authorities to resolve the dispute. Learned counsel for the respondent authority at the outset submits that the dispute is contractual in nature, and as such jurisdiction of the writ court ought not to be permitted to invoke by the petitioner for getting the remedy as prayed for. That apart, clause 29.2 of the agreement itself is argued contemplates that all disputes in regard to the implementation of the agreement would be referred to an arbitration nominated by the general manager of the Southeastern Railway. As such, it is argued that the petitioner is not entitled to any relief as sought in the writ petition. It is further contended by the learned counsel for the railway authorities that clause 6.0, 6.1 and or 6.4 contemplate adjustment in advance lump sum lease freight due to non-loading of brake van, SLR, parcel van. It is submitted that due to the stoppage of the loading and unloading by the petitioner, huge losses are being suffered by the railways unnecessarily during the period when such operation was seized. It is thus submitted that the writ petitioner ought to be dismissed on the above score. Upon considering the nature of dispute involved, it is evident that although the railway authorities entered into an agreement with the petitioner, such contract was executed in terms of the public duties discharged by the railway authorities. Moreover, due to the nature of the allegations made in the writ petition, an alternative remedy cannot be an absolute bar for the writ court to interfere, even if such alternative remedy is available to the petitioner. As held by the Honorable Supreme Court in Uttar Pradesh Power Transmission Corporation Limited and another, versus CG Power and Industrial Solution Limited and another, reported at 2021 Volume 6 SCC 15, availability of alternative remedy does not prohibit the High Court from entertaining a writ petition in an appropriate case in the situation as indicated therein, namely, where the writ petition seeks enforcement of any fundamental right, where there is a failure of principle of natural justice, where the impugned orders or proceedings are wholly without jurisdiction, the vice of the acts is under challenge. In the present case, it can be surely said that the principle of natural justice have been flouted by the railway authorities in threatening termination of the contract with the petitioner in a manner unbecoming of public authority, even without taking any positive steps to resolve the dispute specifically raised by the petitioner, thereby contravening clause 8.8 of the agreement itself. That apart, the section by the railway authorities threatening termination of the petitioner's contract before resolving the dispute raised by the petitioner and acknowledged to have been raised by the railway authorities is patently arbitrary and dehodes the authority of the railways. Clause 6.1 of the agreement, as pointed out by the learned counsel for the respondent authorities, contemplates situations where railway administration is to give guarantee to provide leased parcel space of the brake van, parcel van as per terms and conditions of the agreement. Only in case of the railway's operational exigencies, examples of which have been given in clause 6.1, the railway administration shall not be held responsible for not providing the guaranteed service of the leased parcel space. Since no such exigencies have been pointed out at any point of time by the railway authorities, either to the petitioner or before the court, or in any communications to the petitioner, it cannot be said that clause 6.0, 6.1 and or 6.4 of the agreement are attracted to all the present case. Insofar as the operation of clause 29.2 is concerned, since the railway administration has not yet decided on the dispute raised by the petitioner, either by refuting or conceding the same, it will be premature to say that the matter ought to have been referred to the arbitrator. That apart, it is well settled that mere existence of arbitration clause does not stand in the way of the High Court exercising its jurisdiction under Article 226 of the Constitution of India, where a patent jurisdictional error and or arbitrary action has been committed by the public authorities. Clause 8.8 of the agreement squarely provides that in case of dispute on the part of the railway's discharge of obligation, where lease contract could not be operationalized by the leaseholder or suspended by the railway in certain circumstances, like change of loading or unloading point, not providing service, not providing sufficient time for loading, or other operational problems, the railway administration, CCM, shall be empowered to deal with such situation as deemed fit, depending upon the merits of the case as they are doing de facto. If later on the problem is resolved by the railway, the intervening period involved in resolving such disputes, non-operationalization of the contract, non-loading by the leaseholder due to dispute would be treated as dice non. In the present case, unfortunately, the railway authorities have not taken any steps towards resolving the issue raised by the petitioner in respect of unavailability of sufficient time for loading and other operational problems. It is incumbent upon the railway authorities to resolve the dispute immediately and to treat the period from the date when the petitioner raised the objection, that is on May 29, 2022, till the date of resolution of the dispute as dies none. Insofar as the losses allegedly suffered by the railways is concerned, it is none but the railway authorities who are to blame for such losses, if any, since having acknowledged the problem raised by the petitioner by way of written communication, no action for the resolution of the same was taken at the ends of the railways. In such view of the matter, WPA number such and such is allowed, thereby setting aside the communication dated June 1, 2022, Annexure P9 at page 62 of the writ petition, whereby the petitioner was directed to start leasing operation as early as possible. Otherwise, penal action would be initiated against the petitioner. The respondent number 6 shall decide on the objection raised by the petitioner in the petitioner's communication in respect of the loading and unloading problem and ancillary operational problem as expeditiously as possible, positively within 4 weeks from date. Immediately upon such resolution, which will be taken in accordance with the law, and upon giving an opportunity of hearing to the petitioner, the respondent number 6 shall intimate the outcome of the same as well as the date of the resumption of operation, giving reasonable period for so resuming to the petitioner. It is made clear that the merits on contention raised by the petitioner and or refuted by the railway authorities have not been entered into by this court, and it will be open for the respondent number 6 to decide the entire issue independently and in accordance with law without being influenced in any manner by any observation made by this court hearing. It is also made clear that the entire period from May 30, 2022 till date of intimation of the resolution, whichever way reached to the petitioner, shall be treated as dice non, my lord. In terms of clause 8.8 of the agreement between the petitioner and the railway authorities, there shall be no orders to cause. My lord, this interim order is still there because, my lord, thereafter what has happened, they've provided me with the hearing. My lord, I was present in the hearing and the hearing took place and the impugned speaking order was passed. My lord, what is there in the impugned speaking order is this: before the impugned speaking order was passed, my lord, the terminal changed. They themselves changed the terminal from Bangalore to SMVP. Now that is not highlighted in the speaking order. In the SMVP, my lord, was pleased to inquire from them through an affidavit whether there is a separate terminal or not, because this is a precondition. If there is a separate terminal, that facility has to be provided. And now, my lord, that will be evident from the railway's own affidavit in opposition. My lord, will come at page 12, because they have used two affidavit in opposition.
Yes.
Last occasion, your lordship directed to give me a report whether there is a separate parcel siding or not.
May
Is the last one.
Yes, my lord, kindly come to the affidavit in opposition which has been affirmed
at Yashwantpur
on 14th of December 2022.
Destination station Yashwantpur.
14th of December 2022. The opposition, page 12. What they have stated.
14 December.
14 December, lordship, two affidavits. This is the affidavit which they have served. Just 14th of December 2022. Lordship has found, my lord.
4th January 2023.
Lord, that is the afterward, my lord. Before that, after report, there was another affidavit that is of 14th of December. This was affirmed before the commissioner on 14th of December. Probably my learned friend has a copy. A copy.
14th of December. Lordship, kindly take it.
You have not filed.
Oh, you have not filed.
That is with me.
He also load and unload the parcel within the available time of arrival and departure of rakes as per clause 11.5. My lord, this is what they have stated in the affidavit. Now, my lord, they say that if there is a facility of separate terminal, then this facility will be provided. If there is none, you have to do it within the available time. Now, my lord, kindly come to the latest affidavit in opposition. কোথায় latest? Latest. No, এবার ছোট না।
Dated 16th March 2023.
হ্যাঁ, একটু বলুন, আমি কাছে পাচ্ছি।
16th March.
এ করা আছে।
Your Lordship got it?
আমাকে দেবে একটা করে দেবে।
একটাই কপি আছে।
আমার মার্কিং করা আছে 16th মার্চটা। Here, my lord, they have said, you kindly coming because I had marked it in my ages. Yes, my lord, kindly come to page 6.
ঠিক আছে?
Yeah, page 6, paragraph 10, Roman 10.
Yes.
That at the time of hearing on 13th of February 2023, the point was raised by his lordship to take instruction whether there is any separate terminal is available at SMVP station of the Bengal divisions for loading and unloading or not. My lord, then my lord, kindly see that from the report of the senior divisional commercial manager Bangalore, Southwestern Railway dated such and such, it is found that there is a separate parcel siding for loading and unloading of leased VPHS terminal and in Yashwantpur station.
So there is a separate.
Yes.
Your Lordship,
And that apart, my lord, it was all along contended that if there is a separate terminal, the facility of free time will be provided. My lord, kindly come to page 100, and there is also a provision in the policy also that in respect of loading and unloading, if such situation demands, Chief Commercial Manager of the Zonal Railway has a power to relax it because it does not involve any financial implications upon the government. And the report also, my lord.
11 and 12, how are they contradictory?
11.3, my lord.
No, this is 4, 11.
Yes, they have made a contradictory statement.
Page 6, it says that there is a separate parcel sliding for loading unloading. Page 7, Roman 12 says there is no provision for separate terminal and there is.
Now, Lordship, kindly come to page 12. Page 12, what they have.
Your Lordship, kindly come to the annexure, last page.
My lord, kindly come to page 12.
Yes, Your Lordship, kindly come to annexure.
Page 12, my lord. First paragraph. Page. There is a separate parcel siding for loading and unloading of parcels of leased VPH at SMVB and in Yashwantpur railway stations. Now they take another point, my lord, which is nowhere to be found anywhere. The daily trains having platform turnaround with leased van are not allowed for loading and unloading at parcel siding. Loading and unloading in these trains is permitted only on the platform due to operational constraints. Except for train number such and such, no daily train is having PTFR, no other daily train. These are the things. Now they are coming with all these pleas which are not supported by their rules and
if there
actions. Now, my lord, only the question which was raised on the previous occasion with whether there is a separate terminal or not. If there is a separate terminal, then I am entitled to, as per the lease agreement and as per the policy, I have annexed the policy also. Lordship, kindly will see the policy, what is policy says at page 102. Page 102, my lord, 23.6. last clause, my lord. Lordship has found, my lord.
Yes, I mean.
3 hours free time, 23.6. 3 hours of free time from the time at which the parcel vehicle is placed in the position shall be allowed for loading and unloading of parcels in case the leased parcel vans placed at separate terminal at originating station and destination stations. The word used certainly shall. And only thing which they were asked to produce before this honorable court, whether there is a facility exists or not. It is not I have stated, they have annexed it. I all along said that there is a facility, you are providing the facility to other trains. You are not providing this facility to my train. There is a policy, there is a facility, so there cannot be an incumbent or impediment in the way of asking this. This could have been sorted out from your end. It's unfortunate that I have approached before this honorable court on 2 occasions asking for this basic relief. And in the supplementary affidavit also, my lord, I have stated that which are the trains which are getting the facilities. Kindly see page 21. They have not denied of my supplementary affidavit.
Supplementary affidavit of 20th March.
Yes. Yes, my lord, 20th March.
Page 21.
Page 21. These are the name of the trains I have stated. SMVP Bengaluru Superfast. These are getting Danapur. Then second one, Duronto Express, Howrah, same line. They are getting the facility. But unfortunately, I have been victimized. I have been not being provided with the facility of these basic things. And page 20 Lordship will find the page 20 of the supplementary affidavit that the terminal, which was earlier was Yashwantpur, has been changed to SMVP. Kindly mark the date, 29th of July 2022. That is before the impugned speaking order came. Impugned speaking order, Lordship, which I have annexed, is of 16/8/2022. And this change of the terminal is of 29th of July 2022. And now, my lord, kindly see one last provision, which I will say page 110, my lord. It has given power to the zonal railway to relax some of the conditions. Page clause 32.1 at page 110. Zonal railways in exceptional cases with the personal approval of chief commercial manager may relax some of the conditions which have only the local bearing and has been no financial implications. These includes issues related to loading, unloading problem and other problems. They have the power. My respectful submission is this, my lord. I want to operate this parcel space. Facilities are there. Railways have also stated time and again, because I think my learned friend is representing both the railways. He should at least say that Southeastern Railway has also tried their level best from their end. If your lordship kindly come to page 74, what Southeastern Railway has said to the Southwestern Railway. Page 74 of the writ petition.
Is arising out of Southwestern.
Southwestern and Southeastern Railway is requesting Southwestern Railway that kindly look after it. You have the facility, you can give it. This is my learned friend's letter. Page 74. Leasing operation of LVBH by train number such as has been discontinued from 30th of May 2022 by DG Raj Highway and the same intimated by reference by showing reason of inconvenience and difficulties faced by them during loading, unloading and YPR. And also request you to solve their issues so that they can restart the operation of the LVBH at the earliest. However, it is also mentioned here that by the termination cancellation of the said lease will fetch a huge loss in railway revenue to such an extent. In the instant case, as informed by the leaseholder, they are getting 3 hours of loading and unloading to the leased LBH by train number. But often, late running of train, their allotted time being reduced. Additionally, as they have to load unload from the said LBH platform congestion during arrival and departure of the said train and obstruct the smooth operation of handling of packages gets delayed. In view of the above, to redress this grievance, request for separate LBH by leaseholder may be considered if found operationally and commercially feasible at your end. Either, if possible, request for sufficient free time for loading and unloading may be considered so that the same can be ensured during the platform congestion, and whatever may be the suitable according to the overall feasibility at your end. So this is a letter which has been issued by him to the Southwestern Railway. So this cannot be, Lordship, my respectful submission, as per my little understanding, Lordship, this cannot be ignored. Honorable Court has said that this problem needs to be resolved. And moreover, the Lordship has inquired and it has been submitted on oath before that facility exists, but still they will not give me. They are giving it to other trains. There is a violation of Article 14. There is no reason that I should not be provided with this basic facility. How will I do my business, my lord, if I am not getting the appropriate time? Because 3 hours time and 3 hours time, that's 6 hours times. Now they are saying within 20 minutes or within 1 hour, you have to do each loading and unloading. That is not humanly possible. Neither they have the infrastructure, nor I have the manpower to do it.
Let us hear the rules.
Your Lordship, kindly come to page 49. This is the agreement. Your Lordship, kindly come to 11.6. There is specifically stated that if there is separate terminal, then the petitioner will get 3 hours for loading and unloading.
Yes.
On the last occasion, your Lordship was directed to submit a report whether there is a separate terminal or not. That I have submitted through affidavit. Your Lordship, kindly come page 12 of my last affidavit. Dated 16th March 2023.
This is 6.1, the separate terminal clause in the agreement.
No, 11.6, 11.3 and 11.6.
11.6 and 11.5, where there is stated. Your Lordship, kindly come to page 49.
Yes.
11.5 and 11.6, both are there.
11.5 and 11.6.
Yes.
In 11.6, it is specifically stated that where there is separate terminal, then the petitioner will get 3 hours time for loading and unloading.
Yes.
The petitioner has signed this agreement. Thereafter, your Lordship, on the last occasion, directed me to file a report whether there is a separate terminal or not. That I have affirmed, my lord. Your Lordship, kindly come to page 12. There is, your Lordship.
Yes.
Page 12, that annexure.
Page 12, yes.
There is a separate parcel siding for loading and unloading parcels of leased VPH at SMVB and in Yashwantpur railway station. Point number 1. Point number 2, daily trains having platform turnaround with leased parcel van are not allowed for loading, unloading at the parcel siding. Loading and unloading in these trains is permitted only on the platform due to operational constraints, except for train number this and this train, my lord. No daily train is having PFTR at SMVB and YPR. No other daily train having PFTR has been granted permission for loading and unloading in parcel siding at SMVB and YPR. From
policy, against the policy.
No, my lord. This train is, my lord, getting the facility of PFTR. So, my lord, this train could not get the facility of separate siding. This is the
Where is that rule?
that rule.
Because the policy says if there is a separate siding, that all the trains are entitled to get 3 hours.
Kindly bear 1 minute time.
Policy also says, agreements also says. Both the says, because at this administrative action, my lord, has to be in convergence with the policies. It cannot violate that.
That's not my.
Yes. Executive.
Operational department has decided
How, on what basis? They
whether
cannot
this
decide
train could
arbitrarily.
get that benefit or not.
They cannot decide arbitrarily. They have to decide on the basis of the policy. If you want to take instructions, please take instructions.
Lordship
You
kindly,
cannot go against the agreement.
Lordship kindly fix it on 29th, next Friday. I'll take instruction, but within this period.
Probably 29th is a holiday, my lord.
29th.
29th holiday.
Nah.
There is no holiday. It's a sectional holiday. Please
Acha.
don't get
No.
confused. We are all here.
Then your Lordship kindly fix on 29th.
The interim order is there till 30th, my lord.
Yes, yes, 29th it will be heard out.
Probably 29th is the 30th is the date of interim order expiring. Man. If your lordship extends the
No,
interim
no,
order,
no. Your Lordship kindly fix it on 29th. Only one, yes, yes. If it is not taken up, then your Lordship kindly extend.
Third learned counsel for the petition. Paragraph. In response to a query made by the student as to whether
বন্ধ করলে পরে ওইটা ফাইলটা দেখো।
শেষ হবে।
there is a separate terminal available at SMVB station of Bengaluru division for loading and unloading, comma. The railway authorities, comma, by submitting a further affidavit, comma, has stated that there is a separate parcel siding for loading and unloading of leased VPH at SMVB terminal and in Yashwantpur railway station. Correct.
315 last matter.
Clause 11.6. This is the agreement.
Yes, agreement 11.6 and policy is 23.6.
of the
Railway board
agreement.
policy.
Says that 3 hours free time from the time at which the parcel van / vehicle as placed in position, comma, shall be allowed for loading or unloading of parcels in case of lease parcel vans placed at separate terminal at originating and destination station. Referring to a letter issued by the senior divisional commercial manager, comma, Bangalore on March 6, 2023 to the senior divisional commercial manager, comma, Kharagpur division, comma, Southeastern Railway,
29th holiday.
learned counsel for the respondents submits that the authority has decided not to provide the facility for loading / unloading at the parcel siding for trains having platform turnaround after shopper, platform turnaround with leased parcel van. So, it is not clear as to how such decision has been taken by the authority in contravention of the lease as well as railway circular. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 29.
Only one thing, my lord, 30th is the Saturday. The interim order is still Saturday, my lord. By chance, my lord, there is
On 19th, my learned friend will mention if it is not taken up by your lordship and your lordship.
because there are full court references, my lord. Usually we enjoy, I don't enjoy, but 3:30, my lord, there are full court references. That is the reason, my lord, if it can be extended for 2 days. So that at least 2 to 3 days.
Next week actually will be a little difficult, so why don't you come back on,
Tuesday, my lord, this Tuesday,
not Tuesday, next Tuesday week.
this Tuesday week.
I'll let it be extended for some time, till the 19th. closing date.
Till
ওটা 3rd October করুন।
Yes.
And let
আমি
it
আরো
be
সময় পেয়ে
extended till 10th October. 1 week thereafter.
matter to be listed
Third.
3rd October.
3rd October and 10th.
Your lordship kindly extend the interim order till 3rd or 4th.
10th, I've said. 7 days thereafter.
My lord, your lordship kindly
Let it appear under the same heading on 3rd October. Paragraph, the interim order granted earlier is extended till 10th October or until further orders.
your lordship kindly extend the 5th, my lord, at least 5th. Your lordship kindly take it up.
7 days, sir.
Railway is also suffering a huge loss.
My lord, Honorable, this court has said, my lord, this is for them. Because they have the facility, but they will not give.
That is
They
your
are giving to
That is
others.
provision, I think. That's what.
And their executive action, my lord, as I have overheard during the conversation, my lord, it's only an executive action. It does not have the sanction of law.
Over here, conversations between the department. Forget about that.
Any.
Next,
So I'm for the repetition.
My lord, affidavit in opposition already served, my lord.
Reply also filed, my lord.
My lord, it is not yet served upon me. Yesterday, at 5 PM, my lord, his
What?
clerk.
On previous occasion, my lord,
No.
I have filed my reply. Then there I have. It received.
next.
কোথায় রিসিভ লেখা আছে?
Number 325.
এটা তোমরা রিসিভ করেছো আমার
কালকে।
কপি। Till date, my lord, no copy has been served.
Reply.
Copy of reply, yes.
এটা বারবার করে বলছি।
Your lordship,
my lord, I really don't know, my lord.
Please serve another copy.
yes, yes. Just now he has served.
But I have not stated anything different, my lord. We can take this matter, right?
Ever.
আপনি কি করবেন এখন?
Your lordship, kindly take it about Tuesday.
Tuesday?
So let it appear on the same day.
Same day? My lord,
Your
intro
lordship,
and
your
here
lordship,
also.
kindly fix it at Tuesday.
Anything, my lord.
Tuesday.
Next week is little difficult.
Then lordship,
There are a lot of matters. The same order.
same order.
Affidavits are exchanged, stop. Copy of the affidavit in reply is made over to learned counsel for the railways in court this day. Paragraph, let the matter appear under the heading 7 hearing on the other third, no? 3rd October and 10th October. Paragraph, the interim order granted earlier is extended till 10th October or until further orders.
Grateful.
Comma, whichever is it. The same issue.
Issue is,
No.
here is the issue is, my lord, I was facing an inconveniences, more or less same. I have approached before this, approached the authorities. Authorities acknowledged this problem and thereafter directed the Central Railway to redress this issue. But they have not redressed the issue. As a consequence, I have suspended this operation. I approached before this honorable court, my lord. Lordship was pleased to grant me a relief to this and no coercive action should be taken. Now, my lord has also directed them to resolve this issue. Now, in the opposition, my lord, nothing has been said whether the problem will be resolved or not. But at the same time, threat has been given that your contract should be terminated. This is, lordship, I have the opposition with me.
Give necessary instructions
Yes, yes, I have.
to resolve the issue.
Yes, yes.
Opposition.
Your lordship, kindly take it upon 6th. As your lordship extend the interim order till 10th, 6th.
Both the matters.
No, this matter.
Pashul, equal to 6th.
They have threatened me with the termination, my lord, in the opposition. But lordship has directed them to resolve this issue.
Learned counsel, come back. Please come back with this.
6th. My lordship, both the matter 6th.
No.
No, this matter only.
This matter.
The earlier one will be on
Lordship, interim order is till 10th.
10th. In both the matters.
Yes, grateful.
এটা আজকের ডেটে রিসিভ করে নাও।
My lord, I feel embarrassed to be before your lordship, my lord. It is not my matter. Item number 19 of today's list, my lord, the advocate, my lord, he, my lord,